The House will please come to order. Representative Western, do you have a privilege?
Mr. Speaker, privilege of the floor.
Please.
Members, I want to introduce a constituent of mine. I want to introduce Ryan Good. Here, Ryan, let's have you stand up real quick. He's a young man from Manchester. He's incredibly interested in politics. I know he's got a bright future. So let's give him a warm house welcome.
Welcome to the House. I think there's a lot of sentiment around that early question for the afternoon, is my guess. But anybody else got a privilege? If not, we're at that. Oh, that's right. Chairman Eklund, you've got a report to do.
Mr. Speaker, just kind of an interesting story. Some of you, when you talk to out-of-state people that, especially government officials from out of state, they'll mention that what you need to do is get your staff busy and working on this. And so for most of us, anyway, I got my staff busy and working on it, and she found them at home.
Yay! So let's thank Susie Eklund for all of her hard work to help Chairman Eklund. Representative Alaman.
Point of order, Mr. Speaker. There was a phone switch up down in the lunchroom. If anybody's missing your phone, I turned it into LSO this afternoon. What we think happened, they picked up my phone and left theirs, but my phone showed up, and theirs is in the LSO.
All right, thank you, Representative Alaman. Anybody else have a privilege? If not, all right. We're at that order of business of bills on third reading and final passage with the regular list. The first bill for our consideration is House Bill 92. The reading clerk will read the bill.
House Bill 92, sponsored by Representative Stith, Protection of Parental Rights, an act relating to parental rights, be it enacted by the legislature of the state of Wyoming.
We have amendments. That would be Representative Haroldson. Representative Haroldson, if we can, somebody find him. There he is. Please go ahead.
Thank you, Mr. Speaker. So I move House Reading Amendment number third reading amendment number 1, is that correct? To House Bill number 38 and ask for your favorable consideration. So
that would be third reading amendment number 1 to House Bill 92. 92.
Sorry. Is this delete the Zwanas amendment?
Yeah.
Okay.
Yeah.
I can work on that.
And remember,
Okay, so I will move
yeah,
third reading amendment number 1 to House Bill 92 and ask for a favorable consideration. Sorry, guys, about that. So this would be the deletion of the Zwanazur amendment from yesterday. And I just wanted to kind of bring forth this conversation. We were cruising along yesterday, and I don't know if we fully understand what we did as we were walking through this. So as I looked at it later, I came to this conclusion that there was a gap here. One of the things that I learned early on in seminary, as I was doing the ethics portion of seminary, is they went through and they talked about state law when it comes to confidentiality with people that you work with in the realm of a counselor. And they said you have the obligation to have 100% confidentiality with that person until the point where they express to you the fact that they have either been abused or feel like they're in a place where they are threatened or in a place where there could be an issue. And at that point, you have one job to do as a pastor, and that is to call law enforcement. Legally, I have to. And we find that in Wyoming Statute 43205, as well as 35-20-103, we have to do that. Not just us, but teachers, but everyone. So if we're being 100% honest, if we pass this through, where it says here, nothing in this subsection shall prohibit a school district from adopting procedures that authorize school district personnel to withhold from disclosing to a parent or a guardian information about their student's physical, mental, or emotional health or well-being, in a reasonable, prudent person would believe that the disclosure would result in abuse. So, the reality is, if a teacher felt like a student was going to be abused for a decision they're making about their life, by these statutes, they have to call law enforcement. Not only not tell the parent, call law enforcement. So I believe this is in direct opposition to statute. I don't believe this is something that we should have passed or probably could pass. And at the end of the day, I'm not quite sure why we're even passing this, because the testimony we heard was the fact that we had a student in this state who that information about their decisions or their health decisions were kept from the parents, and now it's sitting in a lawsuit in this state. And so I felt like this was a way we were trying to fix that, and I believe that this amendment goes hard against what we were trying to do in the first place of fixing this parental rights conversation. So with that, I'm just going to open up the conversation and ask for a favorable consideration to the striking of this.
Representative Zwanitzer Dan for your first time.
Thank you, Mr. Speaker. Should come as no shock to anyone, I would ask you to vote no on this amendment. So again, these are in the Child Protective Statutes of Title 14, Article 2, and you can look at the references where it defines abuse and neglect of a child for child protective services purposes, on when you do have to call law enforcement, when you would have to call the department that deals with abuse and neglect when it comes to children. So there is a difference there if you're thinking what abuse or neglect mean in overall law enforcement versus when we talk about a child having to go into custody. I could read you those definitions, but I don't believe necessarily that the intent of putting them in the bill on second reading was to mirror the language in another piece of legislation when it came to parental rights and education. And so really, the purpose of the amendment was to keep our laws consistent should both of these bills pass. I still think that's a good idea. I mean, vote your conscience, but I do think that, you know, like all things in law, we need balance, and it works both ways. And I don't believe necessarily that if a prudent, reasonable person who's gone through training believes that a parent is demanding information, and that information could harm that child for whatever reason. I do think they escalate it, right? I don't think it's just, hey, the parents want this and the teacher says no. There's a whole procedure in place that we're asking to be done here in the schools. So obviously this is not as simple as just, you know, he said versus she said, and we don't get that information. It does allow this to be escalated, and in good faith, all parties be resolved, you know, without what we talked about yesterday of unreasonable litigation, just to sue a school district for money just because, well, there are people in our society, as I think we're all familiar, who are looking for lawsuits to sometimes push a political agenda. What this does, I think, is balance the field and ensures both sides are represented, and it is escalated appropriately, shall we say. And again, vote no on the amendment.
Representative Ward for your first time.
Thank you, Mr. Speaker. On and for this amendment, I want to emphasize that both Title IV and Title 35, that's 4-3-205, 35-20-103, require all parents of Wyoming, including teachers, to report suspected abuse or neglect of a child. The amendment we adopted yesterday upends the current legal structure surrounding mandatory reporting. It suggests that teachers and staff, quote, should withhold information from parents if they believe abuse is happening at home, which runs counter to current legal requirements. If a teacher suspects abuse, They are required to report that suspicion to the proper authorities first and foremost. Our laws should not empower any adults to keep any secrets from parents. Suspicion of abuse should result in a report. Suspicion of abuse is not the same as suspicion of disagreement with a child's self-identification. This amendment would, in a roundabout fashion, allow teachers to hide information from parents if they believe the parents will disagree with the child's self-identification. On and for the amendment.
Chairman Washut for your first time.
Thank you, Mr. Speaker. Just a couple things that crossed my mind during this. Number one, I think there's an important distinction between a child who's being abused and you have reasonable cause to believe that child's being abused, and the belief that abuse may occur if we disclose this information to the family. I think you're required to report when you have reason to believe that abuse is occurring. If you have a belief that abuse might occur, if you make that release, I'm not sure you trigger the mandatory reporting element because no abuse has occurred at this point. But I'm wondering from the teacher's perspective or the counselor or the school district employee's perspective, what information would you likely have other than the belief of the student who's relating concerns? What other investigation, what other method do you have to acquire additional information beyond the subjective belief of the student that if my parents find out, bad things might happen?
Representative Penn for your first time.
Thank you, Mr. Chairman. A couple of things. There was an argument brought up that this could create frivolous lawsuits. I think that's very unlikely to happen. A parent would still be required to pay for a lawsuit, and I doubt anyone's going to incur their own financial strain just to get back at a school district for something. But really, the big issue I think of this is we're talking about getting in the middle of a relationship between a parent and a child. It was brought up that if a parent is calling a school and asking for information, that there may be times when they should keep that away from them. That's the whole purpose of this bill, is that that does not happen. When we're talking about our kids, parents have a tendency to get passionate, and if a parent sees a principal or a counselor or someone at that school as intervening or interfering in what access they have to information about their child, it's possible that they might get a little bit upset. That happens daily at schools when parents are upset at administration or teachers or any others because of what may be happening. But if this opens that up for the interpretation that because this parent's upset with me, then this parent's going to go home and beat their child, and therefore I'm not going to give him any information, I think that defeats the purpose of the bill. So I would recommend an aye on this amendment. Thank you.
Representative Craigo for your first time.
Thank you, Mr. Speaker, and I have a question for the bringer of the amendment who's tied up right now with the other country lawyer. But really and this is a tough one, because I think we're trying to kill too many birds with one stone in this particular amendment. I'm not sure it gets to all of what we need to do, and really I say that because there are instances where kids do go to their school officials and say, I'm being abused, or relay a story, and then maybe they don't say I'm being abused, but something's happening to me at home, and we get that through, maybe it's through the counselor, and it's verified, right? As several of the speakers already mentioned, they are mandatory reporters. They are mandatory reporters to law enforcement. They are not a mandatory reporter to the parent. And so my question is, does this amendment change how that works? Because right now the way it works is the school alerts law enforcement. Law enforcement looks into it. They probably talk to their county attorney office, and they decide whether there is abuse or there isn't abuse, or whether there's a likelihood. And then they do an investigation, and that will include talking to the parent, talking to the student. I'm a little bit worried about taking that language out, because although I don't necessarily like exactly how the language is written either, I do think it's too broad. But I'm afraid if we don't have some sort of language like that in there, we're going to get into a situation where law enforcement feels like they can't actually investigate what might be real abuse. And that's why I say I think we're trying to cover too many things in the language that's already in there. I agree, but by taking it out, I think we also cause the problem that I'm worried about. And so I'll probably vote against the proposed amendment, at least leave that language in there for now so we have a placeholder that we can talk about, because although it's not perfect, it's better than taking it out, because I think we create a bigger problem when we're trying to cover an issue regarding parental rights, which I'm supportive of. I don't also want to put our law enforcement in a situation where they can't effectively investigate what is real abuse, because there's lots more of those types of cases on a daily basis in all of our counties than there is of the other issue we're trying to deal with. And so I would just ask you to think about that, and hopefully, at this point, I'm asking for a no vote on the amendment.
Representative Rodriguez-Williams for your first time.
Thank you, Mr. Speaker. I appreciate, on and for the amendment, I appreciate the comments of the Good Country Lawyer, but the reality is that in this nation right now, more and more school boards across all of the states and in all the communities are adopting policies that endanger parental rights. Children's minds, bodies, and family relationships are being damaged. So now's the time to really think about our parental rights statute and strengthen it. Because when you talk about abuse and neglect, we have to consider the fact that there are employees, school district employees, social services employees that are carrying around an ideology or a mindset that believes that if you don't help a minor socially transition, that in itself is abuse or neglect. And that's something that we really need to keep in mind here, because our laws should not empower any adult, especially school personnel, from keeping any secrets from parents. On and for.
Representative Trujillo for your first time.
Thank you, Mr. Speaker. On and for this amendment, I keep hearing that we need to leave it a little bit broad so everybody can have equal ground. The problem is our laws are already broad, and what happened in the town down on the other side from where I live is why we're here today. Because our laws are already broad enough that we're in already a lawsuit about this. We need to protect our parental rights. And part of that is helping the families. So if somebody feels that the child is being abused, neglected, any of that, report it. That way we can see what the family problem is and work on the unit. You guys, we need to work on the unit and not just a teenager mad at their parents for the week. My kid was mad at me for a week because I grounded her. Is that a reason to report me? Fine, report me. And then we can figure out that my kid's just a brat. Thank you. On and for this.
Representative Heiner for your first time.
Thank you, Mr. Speaker. On and for this amendment. In the past, this body has been very hesitant to get involved with an active lawsuit. And this, to me, this amendment that was passed strikes at the heart of a lawsuit that's going on in my part of the state right now. With the school district passed a policy to prevent the teachers from disclosing to the parents what was going on with their child. And that's in the courts right now. So this may not be an ideal time for this body to weigh in on that, because it may sway the judicial system. So I think that we need to be hesitant allowing that kind of language to go into this bill. Additionally, that language appears to be a dichotomy to what this bill is trying to do. The bill's title is Parental Rights. And this amendment appears to me like it takes away some of those parental rights and gives that to the school system to be able to write policy to not disclose information to the parents. And I think the heart of this bill was to increase parental rights. So I'm on and for this amendment. Thank you, Mr. Speaker.
Anybody else for their first time? Anybody for their second time? Representative Hornock for your first time.
Thank you, Mr. Speaker. On it and in favor of this amendment, and just think broadly for a second, I suppose, but teachers don't always know what's going on at home, right? You probably have, most teachers are trying the best that they can. But there's oftentimes a disconnect between, there was with me, my parents didn't know what I was doing at school, right? And then school didn't understand my home life. So you could have situations where the teachers have what they think is the best intent, and then they choose not to disclose because the language in here says nothing in this subsection shall prohibit. That's pretty broad. So you could have a teacher with good intentions withhold information, and then, but generally, when the teacher needs help, most of the time, parents are there to step right in and help the teacher, most of the time. So if you have the ability for a teacher to create a separation, create a disconnect in that relationship, where the teacher thinks they have the best interest of the kid at heart, so they withhold some things. But in reality, the parents would be more than happy to help that teacher figure some stuff out, to help that kid figure some stuff out. They would be more than happy to do that, but there's a disconnect because the teacher withholds information. So this could go the opposite way of what we intend to do. I just think this language is very broad. Let's strike this amendment. Let's vote aye on this amendment, strike this language from the past that we voted on, and you know, we can look at examples and figure that out as we go. But I think this is way too broad. So just, you know, we could get into all kinds of what ifs, but I think the best move right now that we can make is to adopt this current amendment. Thanks.
Anybody else for their first time? Representative Lawley for your first time.
Thank you, Mr. Speaker. I just want to point out, as just a matter of information to the body, that this language is included in a bill that's coming over from the other side of the hall, and it was in the bill that was filed last session on parental rights.
We try not to refer to those
I know.
bills.
All right. But it was also in a previous bill filed last session, so I think that would be good to know. That's where it originated.
We are on this bill and this amendment, Representative Ward. Oh, anybody else for their first time? Okay, Representative Ward for your second time.
Thank you, Mr. Speaker. I just want to clarify what I said previously. I am on and for this amendment. To be clear, yesterday's amendment, which this current amendment negates, yesterday's amendment would in a roundabout fashion allow teachers to hide information from parents if they believe that parents will disagree with the child's self-identification, and it negates the whole point of the bill. No one cares about students more than their parents. If we didn't want to share info with parents that might make them mad, we might not share report cards. Thank you.
Chairman Washut for your second time.
Thank you, Mr. Speaker. So just so we're clear on what we're talking about with yesterday's amendment that's being withdrawn by today's amendment, or being overridden by today's amendment, is this responsibility if their reasonably prudent person concludes that if this information is shared with the parent, then abuse or neglect may occur. So the reasonably prudent person aspect. We talked about this a little bit yesterday. We talked about the assault statute, right? Reasonable person, being reasonably cautious, not the student, not the teacher, not the parent, but this artificial reasonable person is the test. Would a reasonable person who has these facts come to the same conclusion? Okay? And so the language here in this, in yesterday's amendment is looking to the future. If we release this information to the parent, then abuse may occur. If we have the pre-existing abuse or neglect that's already taking place or has taken place in the past, without this amendment, if the teacher becomes aware or the counselor becomes aware that there is abuse or reasonably looks like there's been abuse or occurring or has occurred, then the mandatory reporting elements of the existing statute would be triggered. What's unique about this language is that it is looking forward. We may have a case where there has been no abuse, no evidence of abuse or neglect. But for the release of this information, now we're speculating that in the future, that release of information might trigger abuse. So I think we can delete this language that we adopted yesterday and still trigger a law enforcement investigation in those cases where there has been abuse and neglect up to the point of disclosure.
Representatives Wanitzer Dan for your second time.
Thank you, Mr. Chairman. Just on that statement that no one cares about students more than parents, I wish it were true. I think we all wish it were true. But I wouldn't be a foster parent. We wouldn't have over 600 kids in need of foster parents in the state if that were always true. And that's why we make laws. It's not for everything going well. It's to protect when things go badly. And so I want to make sure to bring you all back. This bill, it's so much broader than gender pronoun names, right? I understand maybe some of you believe that's where this bill came from. I think if you talk to the sponsor, that's not correct. This idea has been around long before a current lawsuit and a part of the state, right? This goes much broader than that debate, and I need us to all be aware of that. I also need to be aware this isn't about the teachers and the parents. This amendment we put on yesterday goes to the school boards, your locally elected officials, once again, who should know best for those districts, right? This is to allow them to put in policies and procedures that work best in that district. And I would believe some of them may agree with some of the other presenters about how the parent-teacher, parent-school interaction should work in that part of the state. Other parts of the state, I think we can all agree, it's a different level, right? Different thoughts based on that locally elected school board. And we should not be taking away their freedom to make those local decisions that they know best. What this amendment does is put into place just the basic level of protection that a school board should be thinking about in these relationships, right? So it doesn't say, let's take the example, you have a non-custodial parent or a parent who's got 25% visitation over the child, right? They want information on what's going on. The other parent won't tell them, said the kid had a bad day, parents aren't talking. Do they get to go to the school and have the school say, here's what's going on with your kid via the other parent, so they can take that information to court and try to sue for better custody under this, potentially, right? I think there's a lot of situations that if you think about, for the health of the kid, we're asking that locally elected school board to put in place the proper procedures on how this relationship works, right? So again, I think it was a good amendment put on yesterday. It was a good thing in the bill last year. It's another piece of the legislation, wherever they may be in the process this year, for your locally elected school board to make the laws and the regulations and the parameters that work best for that local area. Please leave this amendment on and vote no on this amendment.
Representative Rodriguez-Williams for your second time.
Thank you, Mr. Speaker. On and for the amendment. Ladies and gentlemen, this bill is about fundamental parental rights. It's not about empowering school districts. What this amendment does, it assumes that teachers know better than parents, that school personnel knows better than parents. The word reasonable was used by a few speakers ago. Reasonable's gone out the door in today's society. The way one social services employee interprets reasonable compared to a parent differs very, very broadly. This bill, again, is about parental rights, fundamental parental rights. Remember, we do not co-parent with the government. On and for the amendment.
Representative Penn for your second time.
Thank you, Mr. Speaker. I once had a daycare provider that had an email with a little tagline at the end that said, if you don't believe everything your child says about me, then I won't believe everything your child says about you. Which is a joke, of course, but there's some truth that rings there. That's what makes it funny, in that kids are smart and kids are able to manipulate situations. Kids are known to sometimes tell some fish stories and different things like that if they figure that it's going to get them what they want or what they need. The language that we're talking about assumes that teachers know more about the home life than the parents do. And we need to be very, very cautious in what we allow here. Aye on the amendment, please.
Representative Heiner for your second time.
Thank you. Thank you, Mr. Speaker. On and for this amendment. Right now, with this language in the bill, we are interjecting ourselves as a legislature into an active lawsuit, and it will definitely strengthen one side of that lawsuit. I don't think that's what we want to do at this time. That is at the heart of what this says. The school board made a policy. If they thought there might be abuse, not to disclose that to the parents. That's what this is all about. If they suspect that there is abuse, we know we need to go to law enforcement. But that policy that they had is what is at the crux of this lawsuit. And by allowing this language to stay in this bill, we are strengthening one side in that lawsuit, and I don't think we want to do that. On and for this amendment.
Representative Krickel. Okay, anybody else for their second time before the sponsor? Representative Haroldson.
Thank you, Mr. Speaker. Thank you guys for the conversation. I just felt like last night we really didn't have this conversation, so it's good to have it. Thank you for being willing to give that time today to make that reality. Anytime we don't allow parents to have rights in the realm of their children, I really struggle. They have the right to understand, they have the right to know. If there is concern about abuse, then it is the obligation and duty of the school to contact law enforcement. We don't want kids to be hurt, obviously. That's the last thing we would ever want to happen. But at the end of the day, the parents have a right to know what's going on in their children's lives. And we don't want to give a tool to keep parents in the dark. So with that, I would ask for favorable consideration on this amendment. And thank you very much, Mr. Speaker.
All right. All those in favor of third reading amendment number 1 to House Bill 92 signify by saying aye. Aye. All those opposed? No. Division. All those in favor, please rise. All right, less than that, 40, so that was bad hearing on my part. So third reading amendment number 1 to House Bill 92 has been adopted. The next amendment for our consideration is third reading amendment number 2 to House Bill 92, and that would be Representative Haroldson.
Thank you, Mr. Speaker. So I move third reading amendment number 2 to House Bill 92 and ask for your favorable consideration. This is just another opportunity to talk about kind of a liability piece and what that would look like. This very simply on line 32 through 34 makes it very clear what this amendment does. And it states, if a parent's rights are violated under this section, the parent shall have grounds for a civil cause of action against the violation for the actual damages only. And this is in a situation where a child is hurt or injured, or there is a place where money has to be expended to right the situation. The parents have the right to bring a civil suit for not a frivolous, not we're going to get $2 million out of a school system. No, if it's a situation where a child needs help, that there's going to be a payment for that help. And this is just an opportunity for the protection of the children, protection of the parents, and protection of these families. So obviously, it's a kind of a different approach and a different line than what we saw yesterday, but this is not just an open door for civil suit. This is an opportunity for direct, basically payback for damages only.
Representative Stiff for your first time.
Mr. Speaker, members, I would encourage a no vote on this amendment. We did have a pretty robust discussion about this last night. Please vote no. Now, from a lawyer's point of view, I might see this really as an education amendment. It's really about education, because someone's got to pay for my kid's education. And have what's one man's frivolous lawsuit is another person's opportunity. So we don't want to create a cottage industry for lawyers. So please vote no.
Representative Chestik for your first time.
Thank you, Mr. Speaker. On and against this amendment. We just heard in the debate on the prior amendment that prior amendment was an attempt to favor one side of the lawsuit. This amendment is an attempt to favor the other side of the lawsuit, and for that same reason, I would urge a no vote.
Representative Ward for your first time.
Thank you, Mr. Speaker. Parents aren't going to sue school districts just for fun. So this allows an enforcement provision of this law. Otherwise, the law is basically a suggestion on and for.
Representative Jennings for your first time.
Thank you, Mr. Speaker. I appreciate the bringer of this amendment. The other days, perhaps mine was a little bit too aggressive. I don't think so, but I appreciate him bringing this back. Listen, this just limits it. If you're harmed, you have every right to recover. It's a very simple thing. It's not a thing of making a cottage industry for the lawyers. Lawyers are done pretty well, I think, on their own. But this makes it to where if there's harm, and I'm personally aware of several cases, we should not be allowing there not to be some remedy, and this brings it to a place where a civil remedy of recovering your damages is very reasonable. I can't imagine any of you thinking that that the state would reach in and do something to your parental rights, your fundamental parental rights, and not have to at least pay the cost that it cost you to protect those rights. It makes no sense whatsoever. So this isn't being aggressive or creating a cottage industry whatsoever. It's about protecting the fundamental parental rights. On and for. Please vote aye.
Anybody else for their first time? Representative Stivar for your first time.
First for a second.
All right, anybody else for their first time, second time? Representative Stiff.
Mr. Speaker, there is, if we defeat this amendment, there is still a civil remedy for aggrieved parents. That remedy is to go to court and ask the school district to stop, to change its policies, to comply with the law. It's called injunctive relief. What this amendment would do would allow the parent to say, not only do I want the school to stop, do I want the school to comply with the law in the future, do I want it to stop doing things in violation of the law, it would also say, and I want money. And that, I think we need to be careful not to place that burden on the school district's finances. So, on and against.
Representative Stivar for your kind of second time.
Thank you, Mr. Speaker. On for this amendment.
I've been down this road. I had a son that had a face down restraint done to him. About killed him. All right. I had no recourse. I had no recourse. These parents need some recourse. On and for.
Representative Jennings for your second time.
Thank you, Mr. Speaker. So I don't think this is a question of somebody trying to get rich. It's a question of damages. And that was the difference between the amendment yesterday and this one. This one merely brings about some clarification that you can at least seek for the remedy on the damages. And I'm here to tell you, if you have the tenacity to take on the state, they have deep pockets. Well, after this session, they might not have as deep a pockets as they used to, but they have deep enough pockets to take you on individually. And so this is nothing. Was it available before to have civil remedy? Yes. But it's obvious that very few people were willing to go after that, to stand up for their parental rights, their fundamental parental rights. And this gives the clarification to that. It makes a statement that says, yes, the fundamental parental right may be a cause for action to go after the damages that have been done. I don't see why we wouldn't want to do this.
Representative Ward for your second time.
Thank you, Mr. Speaker. School districts who aren't usurping parents wouldn't have a need to worry. And you have to prove damages in court. You don't just get them because you allege them. On and for.
All right. Representative Haroldson, bring her home.
Thank you, Mr. Speaker. Thank you guys again for the conversation. I believe just an open door opportunity for lawsuit is never good, and I'm fully against that. But I do believe if there is a damage incurred, there should be an opportunity for costs to be brought back. I mean, this is a common sense, I feel, for protecting a family if there were to be a breach. Now, I hope and pray this never gets used and it's not an issue. But in this situation that something were to happen, this would give us a protection for these parents and these families and these children. So would ask for an aye vote.
All those in favor of third reading amendment number 2 to House Bill 92 signify by saying aye. Aye. All those opposed? No. Third reading amendment number 2 to House Bill 92 has failed. Division being called. All those in favor, please rise. Okay, all those opposed, please rise. Thank you. Third reading amendment number 2 has failed. 27 to 33. House Bill 92 having been read 3 separate times, the question is, shall the bill pass? Chief Clerk, please call the roll.
Allemand? Allred? Andrew? Angelos? Banks? Bear? Berger? Brown? Burkhart? Byron? Chadwick? Chestick? Clauston? Conrad? Crago. Davis. Eklund. Haroldson. Harshman. Heiner. Henderson. Warnock. Jennings. Knapp. Larson Lloyd. Larson JT. Lawley. Locke. Nyman. Newsom. Nicholas. Nemec. Northrup. Oakley. Obermuller. O'Hearn. Olson. Ottman. Pendergraft. Penn. Provenza. Rodriguez Williams. Rodriguez Williams. Sherwood. Singh. Slagle. Smith. Stith. Storer. Strock. Stivar. Tarver. Trujillo. Walters. Ward. Washut. Western. Winter. Wiley. Yin. Zwanzer Dan. Zwanzer Dave. Speaker Summers. Are there any changes? Warnock. Are there any changes? Locke? No to aye. Further changes? Closing vote. Vote closed. 55 aye, 7 no.
House Bill 92, having received the affirmative vote of the majority of the members elected to the House, House Bill 92 has passed the House. The next bill for our consideration is House Bill 148. The reading clerk will read the bill. Oh, just a second, reading clerk. I'm going to back up a second. Representative Eklund had a privilege that I forgot.
Thank you, Mr. Speaker. In body, I haven't lost anything this time, but this is a privilege, and I can't see past that poll, but a member of my home community and the mayor of Albin is here, and I'd like to recognize him for his thankless job and great work he does. Kelly Craco.
Welcome, Mayor. All right, now I'm going to start over again. The next bill for our consideration is House Bill 148. The reading clerk will read the bill.
House Bill 148, sponsored by...
I got another privilege. Okay, sorry about that, Representative Jennings.
Privilege, Mr. Speaker.
Please.
Up in the north gallery, if they'll stand up, is my son Joshua Jennings. My two grandsons, Christopher and Nicholas. They come all the way from Roanoke. He writes, for those of you that watch The Blaze, he writes for Glenn Beck, and they're up for just a couple of days, and welcome them to the House.
All right, Representative Brown. All right. Anybody else want to do a privilege? Representative Yin, are you there for a privilege? All right. I'm going to try this one more time. The next bill for our consideration is House Bill 148. Reading clerk, this time we're going to let you read the bill.
House Bill 148, sponsored by Representative Lawley, regulation of surgical abortions, an act relating to public health and safety, being enacted by the legislature of the state of Wyoming.
We have amendments, I believe, a amendment, a Representative Yin.
Mr. Speaker, thank you. I move third reading amendment number 1 to House Bill 148 and ask for your favorable consideration. So members, if you take out your second reading Nyman amendment and you look on line 14 of that amendment, the section starts at not less than 48 hours. So what the amendment that I'm bringing today is to strike out that not less than 48 hours period. So members, I was speaking to you all before when we had that second reading amendment about that risk of that forced 48-hour timeline. Again, what I'm solely here for this amendment is to reduce the risk that we're going to come back in a year and then find out that there's a story that a woman has become infertile because of a complication in a pregnancy, and they weren't able to perform an abortion to ensure that woman could still continue to have a family in the future. This isn't a hypothetical. There's a situation in Oklahoma, so Oklahoma had banned abortion, where a lady was not able to get an abortion, but she had what was called a molar pregnancy, so the fetus was not viable. It's a situation where there is plenty of time, but I think it's an example of a situation where if that woman was not able to get an abortion, she would have to wait until her life was actually physically in danger. So 15% of cases of molar pregnancies turn out to be actually cancerous. So in that situation, the cancer grows, and then there's a risk to her actual life at that point. So the situation that I'm worried about is that there's one that we're not being creative enough, since we are not all medical professionals, on a situation where a woman could bleed out within those 48 hours and then not actually get care. It might not even be bleeding out. It could just be damage that comes to their reproductive health in a situation where we've created a situation where that woman won't be able to have children again. I want to make sure that if we're going to pass bills like this, that we minimize the harm that we cause. And the one part that I'm asking here is just to strike out that 48 hours, because I think there is real risk there. It isn't medical necessity. In fact, it could cause medical harm. So I'll ask for your favorable consideration. Thank you, Mr. Speaker.
Representative Rodriguez-Williams for your first time.
Thank you, Mr. Speaker. On and opposed to the amendment. The good representative mentioned harm. When a woman makes the decision of whether or contemplates the decision of whether or not to have an abortion, she's often in a crisis situation. There's things that she's thinking about. And that 48 hours really is a time period for her to think about the crisis that she's enduring and the decision that lies before her. I know that this body really values mental health services and making sure that services are provided to Wyomingites. Unexpected pregnancies often are crisis situations. The decision of abortion ends the life of an unborn baby. And while abortion is on the rise, abortion pill use is on the rise, chemical abortion, there's something called abortion pill reversal. And so often, women take that first pill, one of the two, and they regret it. And they regret it for years. I've met women that have regretted it 40 years later. And I've met women that have actually carried to term as a result of abortion pill reversal. And so I ask this body to honor that 48 hours, to respect that crisis situation so that women can get the help that they need. On and against.
Representative Ward for your first time.
Thank you, Mr. Speaker. I'd like to correct some information. A molar pregnancy is not a pregnancy at all. There is no baby. On and against this amendment.
Anybody else for the first time? Anybody for their second time before the sponsor? Representative Yin.
Mr. Speaker, I'm not going to debate whether a molar pregnancy is a baby or not. According to the definition that I read, it's a fetus with more chromosomes than normal, so it causes an issue where it becomes non-viable. You can decide whether that's life or not. The situation, in that situation, which is one of many, I'm just saying it's one possible situation that many of us don't really think of, right? So when we think of, I think when you all think of whether you want to ban abortion or not, you're thinking about abortions of convenience, but we've also agreed in many cases as a body that when it comes to life of the mother, that is paramount. And so what I'm saying here is that if a doctor says, you really need to get an abortion, but I cannot treat you because we have this 48-hour waiting period, but harm could be caused, Sometimes they might even recommend that you go to another state because you can't get the treatment here. What I'm worried about is that we're going to end up with a situation that we didn't think about where we've caused harm within that 48 hours. And I don't want to have that regret. I think that this is, again, about the health and safety of the mom and even the ability for them to continue having children in the future. Please, I urge you to vote aye on the amendment. Thank you, Mr. Speaker.
All those in favor of third reading amendment number 1 to House Bill 148 signify by saying aye. All those opposed? No. Third reading amendment number 1 to House Bill 148 has failed. House Bill 148, having been read 3 separate times, the question is, shall the bill pass? Chief Clerk, please call the roll.
Allemand. Allred. Andrew. Angelos. Banks. Bear. Berger. Brown. Burkhart. Byron. Chadwick. Chestick. Clauston. Conrad. Crago. Davis. Eklund. Harrelson. Harshman. Heiner. Henderson. Hornock. Jennings. Knapp. Larson Lloyd. Larson JT. Lawley. Locke. Nyman. Newsom. Nicholas. Nemec. Northrup. Oakley. Obermuller. O'Hearn. Olson. Ottman. Pendergraft. Penn. Provenza. Rodriguez-Williams. Sherwood. Singh. Slagle. Smith. Stith. Storer. Strock. Stivar. Tarver. Trujillo. Walters. Ward. Washut. Western. Winter. Wiley. Yin. Zwanzer Dan. Zwanzer Dave. Speaker Summers. Are there any changes? Are there any changes? Closing vote. Vote closed. 53 aye, 9 no.
House Bill 148, having received the affirmative vote of the majority of the members elected to the House, House Bill 148 has passed the House. The next bill for our consideration is House Bill 138. The reading clerk will read the bill.
House Bill 138, sponsored by Capital Finance. State funds, Pool A participation and fund limits, an act relating to the investment of state funds being enacted by the legislature of the state of Wyoming.
Chairman Harshman.
Mr. Speaker, I withdraw that amendment. I really mistakenly approved it, and I shouldn't have. This bill was on consent list, so I urge your aye vote. It's a good bill. Thank you.
Awesome. Third reading amendment number 1 to House Bill 138 has been withdrawn. House Bill 138 having been read 3 separate times, the question is, shall the bill pass? Chief Clerk, please call the roll.
Allemand. Allred. Andrew. Angelos. Banks. Bear. Berger. Brown. Burkhart. Byron. Chadwick. Chadwick. Chestick. Clauston. Conrad. Crago. Davis. Eklund. Harrelson. Harshman. Heiner. Henderson. Hornock. Jennings. Knapp. Larson Lloyd. Larson JT. Lawley. Locke. Nyman. Newsom. Nicholas. Nemec, Northrup, Oakley, Obermuller, O'Hearn, Olson, Ottman, I'm sorry. Pendergraft, Penn, Provenza, Rodriguez Williams, Sherwood, Singh, Slagle, Smith, Stith, Storer, Strock, Stivar, Tarver, Trujillo, Walters, Ward, Washut, Western, Winter, Wiley, Yin, Zwanzer Dan, Zwanzer Dave, Speaker Summers. Are there any changes? Alamand, aye. To no. Knapp, aye. To no. Further changes? Further changes. Closing vote?
Chief, on my screen, it still says 148. Is that a problem? You got that corrected? Are we in the right screen, just to make sure? God, I thought it might be, but I caught it too late.
Were there any changes? I got them, okay. Closing vote. Vote closed. 41 aye, 21 no.
House Bill 138, having received the affirmative vote of the majority of the members elected to the House, House Bill 138 has passed the House. Now, ladies and gentlemen, we've got to go back to introductions. We have to, even though we have mirror bills, we have to introduce both bills on both sides. So we went through House Bill 1, we worked it, but we have to introduce Senate File 1. And so we are at that order of business of Senate files on first reading. The first Senate file for our consideration is Senate File number 1. The reading clerk will read the bill.
Senate File 1, sponsored by Appropriations.
First reading of the bill.
General Government Appropriations 2.
Senate File number 1 is referred to Committee number 2, Appropriations. Mr. Majority Floor Leader, I think we're ready for you.
Mr. Speaker, I move the House resolve itself into Committee of the Whole.
You've heard the motion. All those in favor say aye. All those opposed? Motion carries. Chairman who? Chairman Crago. Yay!
Committee of the Whole will please come to order. First bill for our consideration is House Bill 134. The reading clerk will please read the bill.
House Bill 134, sponsored by Representative Lawley. Property Tax Deferral Program Amendments, an act relating to property taxes. Mr. Speaker, your Committee number 3 Revenue, to whom is referred House Bill 134, Property Tax Deferral Program Amendments, respectfully report, same back to the House with the recommendation that do pass with the following amendments. Ayes, Representatives Byron, Harshman, Northrup, Oakley, Storer, Zwanitzer. Noes, Representatives Bear, Locke, Strzok. Representative Harshman, Chairman. This bill was re-referred to Committee number 2, Appropriations. Mr. Speaker, your Committee number 2, Appropriations, to whom is referred House Bill 134, Property Tax Deferral Program Amendments. Respectfully report, same back to the House with the recommendation that it do pass. Ayes, Representatives Henderson, Larson, Nicholas, Sherwood, Stith, Walters, Swannitzer. Representative Nicholas, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Harshman?
Thank you, Mr. Chairman. I move that when the committee of the whole rise to report, to do so with the recommendation that House Bill 134 do pass, and would turn the explanation over to the good sponsor.
Representative Lawley.
Thank you, Mr. Chairman. I believe there's a standing committee amendment that needs to be moved as well.
You're correct. Chairman Harshman, would you mind moving that standing committee amendment as well, please?
Thank you, Mr. Chairman. And I'd also move that standing committee amendment number 1, and the good sponsor can explain them both. Thank you.
Representative Lawley.
Thank you, Mr. Chairman. What I'd like to do is just give a little brief background on the bill and then address the standing committee amendment. Body, this is a bill we passed last session under House Bill 121 number. It's virtually the same, except for the standing committee amendments that you're going to hear in a moment. So again, we've already passed it, so I'm going to try to work through it quickly because I know there's a lot of bills behind me. I've heard I listened to quite a bit of the Revenue Committee interim and also some of their meetings during this session. And I heard over and over stories about older people in particular who really just wanted to continue to live in their home and live out their life there. And in many ways, that is what the group that this bill is targeting in particular. It is one option of relief for them. It is a property tax relief bill. It is not pretending or masking itself to be a reform bill. But I will tell you this, the bill isn't for everybody, but for those it is for is someone to me, and I hope there's someone to you. And an option that we should offer, we actually already offer it in Wyoming, but it's not available in every county. So the current property tax relief program has been in effect for many years. So it really is something the state recognizes valuable to certain people, even outside of the current property tax crisis that we're in. So I want you to keep that in mind. The problem really is it's not functioning well. We only have one county that's holding it up. It's where the mountains and the prices are high, and they have stood it up in the counties. And the main reason, according to many counties I've talked to, is that they just simply don't have the personnel, the resources really to stand up the program, and the statute requires that they do that in order to offer it to their citizens. So what I've done with the House Bill 134 is amend the current property deferment statute and brought it up into the Department of Revenue to run it statewide. And then they would make the decisions regarding those deferments. And then there's a $200,000 amount of appropriation in the bill, and that is so that the Department of Revenue can give them those counties back the money that they decide to defer back to those counties. The state would hold a tax lien on the property that would be satisfied once the property is transferred for whatever reason. There's no payment penalty. If someone inherits some money or their financial situation changes, they can basically pay off the lien and get it removed from their property. So that's really the program. And then I'll talk, now that you know that part, I will talk about the Standing Committee Amendment number 1. What the Standing Committee, the Revenue Committee did is they listened to some testimony. The Teton County Assessor, whoops, there I went, she testified and provided some really good insight into what's happening there and her view of the program, as well as some other groups testified, and these amendments kind of come out of some of that testimony. The first change you're gonna see, the first line 6 is a change in the title, but then you go down to page 2, line 17, and what they did is the original bill had the deferment of up to half. That was actually in the original statute. You could only defer up to half of any 1 year's property taxes. This Standing Committee amendment changed that to where the entire tax for any given year could be deferred. The bill will still contain the protection that says that once you have deferred up to 1/2 of the market value, you can't do any more deferments. But this for any individual tax year, you can defer, according to this amendment, all of the tax. The second change they made is on page 3, line 22. And what this did was to give the department, and it says the department may, at their discretion, defer priority and take a second lien position. And here's why that they did that, is that they got some feedback that there are some folks that would qualify for this, but that still have a small amount of a mortgage left on their property. And the law requires that the lien holder obviously has to be notified. They have to sign an affidavit to agree to a deferment. And concerned that some people might be left out if they had a small amount and their mortgage company wouldn't allow the deferment. And so that would give basically the Department of Revenue the ability to look at that and their discretion decide if they could possibly take a second lien position to help that property owner out. Again, I've talked to the department and they had no problem with it, especially because it's a may, not a shall, and also because that they use their discretion in doing that. So that's the second committee amendment, which I believe, Mr. Chairman, has been moved.
Is there any discussion on standing committee amendment number 1 to House Bill 134? Seeing none, question having been called, all those in favor, please say aye. Aye. Those opposed, no. Standing committee amendment number 1 to House Bill 134 has been adopted. We are back on the bill. Is there any discussion on the bill? Chairman Northrup.
Thank you, Mr. Chairman. Could you briefly give us a description of basically what happens at the end of the life of the note with the state? Because of course it's half the value, so there has to be some kind of foreclosure process.
Representative Wally.
Mr. Chairman, thank you. Thank you for that question. Typically, how this would work out is that, again, under the statute, there are several things that could trigger the satisfaction of the lien. But typically, it's going to be the transfer of the property. And that could be upon death. It could be someone goes to a nursing home and family member buys it, or they are transfer that property. But any transfer of ownership of the property would then cause the lien to be satisfied before that transaction can be effectuated.
Is there any additional discussion on the bill? Question being called. All those in favor of Chairman Harshman's motion that when the committee of the whole rises to report it, do so with the recommendation that House Bill 134 do pass. All those in favor, please say aye. Those opposed, no. House Bill 134 is passed committee of the whole. The next bill for our consideration is House Bill 52. The reading clerk will please read the bill.
House Bill 52, sponsored by Representative Summers. Property tax, homestead exemption, and act relating to taxation. Mr. Speaker, your committee number 3, Revenue, to whom's referred House Bill 52, property tax, homestead exemption, respectfully report, same back to the House with the recommendation that do pass with the following amendments. Ayes, Representatives Bear, Byron, Harshman, Locke, Northrup, Strzok. Noes, Representative Oakley, Storer, Zwanitzer. Representative Harshman, Chairman. This bill was re-referred to Committee Number 2, Appropriations. Mr. Speaker, your Committee Number 2, Appropriations, to whom's referred House Bill 52, Property Tax, Homestead Exemption, respectfully report, same back to the House with the recommendation that do pass with the following amendments. Ayes, Representatives Henderson, Sherwood, Stith, Walters. Noes, Representatives Larson, Nicholas, Zwanitzer. Representative Nicholas, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Harshman?
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report it, do so with the recommendation that House Bill 52 do pass. It has a standing committee amendment I would move as well, and I'd turn the explanation of the bill and the amendment to the good speaker. Thank you.
Speaker Summers.
Mr. Chairman, thank you. I bring you House Bill 52 and ask for your favorable consideration. So this is a homestead exemption, and I'll just kind of run through it. It goes into the exemption statutes in 3911-105, and it states the following property is exempt from property taxation. You go down to Romanet, so go on to page 2, and you'll see that a portion of property used as a primary residence has a homestead exemption. The following shall apply to the homestead exemption for residential real property used as a primary residence. The following amount shall be exempt as a homestead exemption. For an owner who is 64 years of age or less, the first $50,000 of fair market value shall be exempt. For an owner who is 65 years of age or older, and not more than 74 years of age. The first 100,000 years, $100,000 of fair market value shall be exempt. And for an owner who is 75 years of age or older, the first $150,000 of fair market value shall be exempt. Go on down, not more than one homestead exemption shall apply to the same property. The property is the person's primary residence. Owner means, it goes through on page 4, and it kind of goes through the different types of ownership that exist in Wyoming. And then if you go on to page 5, really what you get into is section 2. And so this bill does a backfill with general fund. And so there's appropriated $88,400,000 from the general fund to the Department of Revenue for the purposes of reimbursement to local government. And so this is an exemption that lasts. If you go on to page 6, this appropriation shall be for the period beginning from the effective date of the act and ending December 31st, 2027. So it's 3 years. And so if you go to the fiscal note, I think you also need to understand that there's an impact to the school foundation program that is not reimbursed out of the general fund, so that'll be a direct hit to school foundation. Will have to be absorbed within the dollars provided to schools. And so that's, you'll see in that it's $34.4 million in 26, $35.4 million in 27, $36.5 million in 28. And so what this bill really does is provide immediate tax relief for 3 years to individuals. And I think we're trying to do several different things. One is cap the rate of increase. 2 is do a rebate program for people, like a long-term rebate program for people that are, that are underprivileged, that have less income. We've also passed a bill that was for kind of long-term homeowners that are older. And so this would provide some tax relief to everybody, and obviously it's skewed towards older individuals because they are the ones most likely to need tax relief on fixed incomes. And then if you go to the standing committee amendment out of good committee number 3, and it has been moved by the bringer, and it basically increases it for those up to 65 years of age or 64 years of age from 50,000 to 100,000. The next category, it raises it from 100,000 to 150,000. And then in the third category above 75, it raises it from 150 to 200,000. And it also inserts an associated, if you look on the amendment on line 17, insert an associated residential land. So it wouldn't just be the building, it would go towards the land. And I haven't tracked in the rest of that amendment that good committee number 3 did, so if they want to further explain that, they can. Whether you want to add more money into this, and I think what's important to understand is if you look at the amendment from good committee number 2, that would be standing committee amendment number 2, which they will bring in a minute. It raises the amount of money from the general fund from 84 million to 123 million. So you really need to decide whether you want to spend that much more money on an exemption. I brought what I brought because I thought it was the right amount. If you all want to put in more money, that's up to you. So if you vote in favor of standing committee amendment number 1, you will be putting more money out to people, but you'll also be taking more money away from the general fund. So with that, Mr. Chairman, I would stand for any questions on the standing committee amendment, and probably I'll have the good chair of revenue answer any of those.
Is there any discussion on standing committee amendment number 1? Representative Locke.
Thank you, Mr. Chairman. I'm on and for the standing committee amendment, raising that up and putting a little bit more relief, leaving a few dollars in people's pockets in the next couple of years and helping us right the ship and move forward. Again, on and for the amendment.
Any other discussion on Standing Committee Amendment number 1? Chairman Nicholas.
Thank you. And this is in part explains the next amendment, but the reason that the Appropriations Committee on Re-referral increased the number from 88,400,000 to 123,400 is because of this amendment. So if, with this amendment, the total cost by lowering it the 5 years and adding this amendment, it increases the budgetary item. So the fiscal sheet would be modified, and that would turn into 123 million. So that's what you're voting on now is on that amendment that came out of revenue for the dollar amount.
Any further discussion on Standing Committee Amendment number 1? Seeing none, all those in favor of the amendment, please say aye. All those opposed? Standing Committee Amendment number 1 has been adopted. Division having been called, all those in favor, please stand. All those opposed, please stand. Less than 41, the amendment has been adopted. We are now on Standing Committee Amendment number 2. Chairman Nicholas.
Thank you. I would move Standing Committee number 2 to House Bill 52 and ask for your favorable consideration. So ladies and gentlemen, this just, now that you have adopted the amendment that changes who can qualify for this, and if you run the math, like if you turn to the fiscal note on the back of this bill, as it originally came out, and the amount then that is on section 2, page 5, line 15, the cost of the program was roughly 88 million. And now we had staff come in, fiscal staff, and walk through it with us, and they said the cost will now be 123,400,000. So that's the number now that this would provide in relief. And committee, on your desk, you all have, well, I'll do that when we get back to the bill. And so I'd ask for your aye vote to make this consistent with that amendment.
Speaker Summers.
Mr. Chairman, thank you. On in support of this amendment, I really believe if we're going to provide relief to the people, which I think we should, I think we have an obligation to provide a backfill to local government. And one thing we got to realize is no county's the same. You know, some counties, like my county, is rich in mineral money. Perhaps the residential piece isn't as big. We have other counties that are very dependent upon residential property tax. And I think I believe it's our obligation to backfill if we are going to take away from local government. So on in support of this amendment.
Is there any additional discussion on Standing Committee Amendment number 2? Seeing none, all those in favor of the amendment, please say aye. All those opposed, no. Standing Committee Amendment number 2 has passed the Committee of the Whole, has been adopted by the Committee of the Whole. We're back on the bill. Is there any further discussion on the bill? Chairman Washut.
Thank you, Mr. Chairman. Question for the good speaker, or perhaps for the good chairman of Revenue. As these different tax relief and reform bills start accumulating, it just seems that there's a great chance that some of them may conflict in some way. And I'm just wondering, has anyone looked at this bill and how it interfaces with all the other relief bills And could someone potentially get relief from more than one of these bills at the same time, and what's the cumulative effect of all that?
Speaker Summers.
So Chairman, the good Chairman of Judiciary, thank you for that question. It's something we're going to have to work out. So for example, I look at the long-term homeowner one, right? And that's a 50% exemption. And so if you have a 50% exemption and you have these folks that in this tier system that are over that and also apply, then they get 2. And so I think as we go through, and so actually I'm thinking on a second reading amendment, for example, that maybe if you get this one, you don't get that one, or if you get that one, you don't get this one. And then I think in the end, I don't like to talk about what happens in the other body, but I think there's got to be a meeting of the minds as we cross these property tax bills over and make sure that we meld them together, those ones that we need to meld together. And so that's, frankly, I'm going to start that Monday or Tuesday with my folks across the way. But I think on this, I think there are things we can do in our readings to try to do some of that. So thank you.
Representative Yen.
Mr. Chairman, thank you. You know, I think one solution to that could be just saying you could only apply for one of the exemptions and not multiple exemptions. So that could be something that we discuss and maybe put in all the bills. The one thing that I like about this bill is actually it defines what a primary residence is. You know, we have a lot of people who have second homes in my neck of the woods who claim it as their primary residence, but Wyoming doesn't really have any primary residence definitions currently in statute. And so I think this would actually help with that situation, because then they wouldn't necessarily be able to claim it on their federal tax return as their primary residence anymore. The one thing that I don't really like about this, though, is because we have plenty of primary residences in Teton County who are multi-billionaires or multi-millionaires. They don't have a fixed income. They keep making money on capital gains or buy our local ski resort. And so should we be giving them a tax exemption? That's my question. Because, you know, my district's full of people who are just trying to raise a family, trying to afford their home, afford their mortgage, but they wouldn't qualify for an exemption under this. So I think that's something that I would really like the body to consider is, do we let people who aren't on a fixed income but are over the age of 65, 75 get this when we have many families that just want to stay in their home that don't get it? Thank you, Mr. Chairman.
Representative Heiner.
Thank you, Mr. Chairman. I like this bill. With an exemption, it kind of addresses some of the things the previous speaker talked about. Rather than a percentage of the cost of the home, the exemption is a certain dollar amount. So those individuals in a home that is not as expensive gets a pretty good reduction in their taxes. Whereas someone in that county, it's a drop in the bucket to their taxes. So this is going to help those that really need it. And I like this exemption approach. I've seen it done in other states. Some of the surrounding states have a similar law, and it's been very successful, that you have to prove residency before you get the exemption, and I like how this bill defines residency. One question I'd like to bring to the speaker is, there's an exemption, but is there a way to make sure that someone doesn't apply for an exemption that has a home in multiple counties? Is there some kind of a cross-check so someone doesn't apply for an exemption in one county and then in another county on the secondary home and game the system in that way? Thank you.
Speaker Summers.
I believe that's covered in the definition of a primary residence, that this is a primary residence. I think that's, but I'll take a look, but I believe that's the case.
Representative Provenza.
Thank you, Mr. Chairman. Yeah, the bringer of the bill talked about how, you know, our older folks are the ones that are struggling most with a fixed income, but I think that might be easy to do given kind of this body's experience in life and where they are. As a young person with a home, it is very difficult to try and climb a ladder, make enough money and survive and be able to pay. So I can certainly understand the plight of older folks, or some of them needing to find help, but for my generation, it's been more difficult for us to be able to afford homes. It's been more difficult for us to be able to get into them. The generations before us have had more access to homes, and most of us are renting. And so I just think that we need, if we want to provide relief and we want to keep our young people in Wyoming, because we bleed young people every year, we have to start thinking about them in terms of relief as well. Thank you.
Speaker Summers.
Mr. Chairman, thank you. And I really do agree with the last bringer. I think it's important. One thing, this provides some relief to everybody. But I think as we go through the readings, right, I don't know what, one is, what can we do in a homestead exemption before we run into constitutional challenges? I think that, you gotta have, that's why I got broad categories. And so, but I do think that's an important piece. I think we shouldn't lose sight of it, that young families struggle as well. And frankly, you think about the general workforce in some of our parts of Wyoming, they're having a hard time paying bills, paying mortgages, paying property tax. So I hear you. I don't know what all the fix is. And in the good land of the Tetons, I don't know what the solution is there. I don't know how you handle an area that is inflated that much. It is just really difficult. And there's some people up there that are in really expensive homes that are on fixed incomes. It's tough. It's tough. But I'll tell you, it's really hard to fix that problem. And so with that, I'll wait for any other questions.
Is there any additional discussion on the bill? Chairman Nicholas.
Thank you. So ladies and gentlemen, you should have distributed around, I just want to run through some data that talks about this, because now we're getting into the larger dollar amounts for the property tax returns. And so it got passed out yesterday. And what this has a breakdown of the total amount of additional property taxes that we have paid as a result of the inflationary components beginning in 2019 through 2023. And it's actually pretty interesting when you sit down and you do the math. And so if you look at this exhibit or handout, first of all, if you go to page 2, let's start at page 2, because at page 2 it talks about what the actual inflationary impact was for each county since 2019. And what's fascinating about this is if you go down to Sweetwater County, the total amount of inflation on home prices for property taxes in Sweetwater County after 4 years of inflation was 19.4%. So less than 5% per year, and close to the mean increase from the prior 10 years. So for some reason, in Sweetwater County, they just didn't have the impacts as other places did. So I just think that's interesting, because the highest one in Teton County is 110% versus 19%. And so there's a huge fluctuation of the actual impact of the increase of property taxes. Frankly, Sweetwater County didn't have any real inflation. They had basically normal inflation. So I think it's interesting if you pick out your own counties. Converse County was 33%, Natrona County was 35%, Niobrara County was 25%, Washoe County was 34%. And so obviously they did not have the huge increases as compared to those upper taller counties. And so the thought of that is, well, does it make sense to give the same type of a cut to the huge disparity of actual increases of what you had to pay? Okay. So next, let's go back to the first page, because let's talk about how much money we collected over and above because of those high increases in property taxes. So the first big column on the left of all those columns there break it down in 2019, 20, 21, 22, and 23. And then it gets the totals of all the counties at the bottom of that. And then on the little box on the right, it has the accumulation of what those dollars all add up to. And so it says the estimated total residential property taxes paid was $2.4 billion. But then it goes and it takes all those numbers and adds the increases by how much property taxes went up from 2019 to 2023 just in hard numbers. And that number is the second item, which has estimated total increases, $254 million. So that's the total increases. And then the next box is, if we had normal inflation consistent with the prior 10 years, and actually the prior 20 years, that's 3.6%. So if you take out normal inflation from that 254 million, that's 233 million. That's the total amount of extra money we paid in property taxes as the state of Wyoming on average for all property taxes on residential property. Then if you change that to 5%, so if you go from 5%, from 3.6 to 5%, that number goes down to 190 million. Let's see if I've got two different charts to make sure I've got the right numbers there. Right. So at 3.6%, it goes down to 195 million. If you go to 5%, that number goes down to 145 million. So just from 3.6% down to 5%. Now you have to recall, we've already passed some tax relief. So if you take that 145 million, so if you want to just go back to our taxes and make them with inflation consistent with 2019, we have another $20 million that we've already put into the budget for our property tax relief. We've got two bills that have already gone out of this body, which add about another 15 million total or plus in tax relief. And so as we currently stand, and with this bill, we'll be actually reducing property taxes more than what we were paying in 2019. So, but I think that's kind of the big picture numbers that we have to think about as we start reviewing each separate bill and how they all add up. Now this bill is 123 million. With the 20 million that we've already put in, we're at basically 5% inflation rate since 2019, without the two other bills or any other property tax relief, which if that's our target, then this should be the only other one that we pass. And if it's not, then we ought to lower this and to balance it out after we all decide what that target is that we want to achieve. So, thank you.
Is there any additional? Representative Storr.
Thank you, Mr. Chairman. I just want to caution the body a little bit. The Revenue Committee's worked hard on these bills, and we really want to hear from all of you what you think. But if we pass all these bills that we are considering, we are going to have some revenue challenges. And I think it's worth thinking about what is equitable and what is fair. That's what our tax system is based on and what the Constitution says we should at least aspire to do. And I'll talk more about that when we talk about a couple of these other bills. But I just was thinking about the different scenarios. You know, if you were 48 years old and you moved homes for your job, you moved towns, and your neighbor next to you is 65 and has lived in Wyoming for, I think we decided on 25 years, right? So that your neighbor's already got it. he's going to pay half the tax that you do, just based on that, even though your houses are exactly the same or close to it. And now we're going to give older people another tax break because we think they're on fixed income and they can't afford their tax. But we've also given them a really great refund program that gives them the chance to apply and, frankly, wipe out their entire tax liability in some cases. So I just think we need to think about a balance. I do believe in a modest exemption. I don't understand why it's age-based. I agree with Representative from over the hill that we really need to think about young people and keeping them in the state and making it so that they can live here. So while I appreciate your support for anything that drops property taxes, I really do think we need to put all of this in context. So we've got a couple more days to think about these bills, what we might want to do with them. I hope you will err on the side of caution before we pass all of them over to the other side of the hall. Thank you.
Chairman Eklund.
Mr. Chairman, I'll try to be brief. I think the majority of us don't plan on leaving here with all these tax bills passed, but they're brought to the floor for information. Some of them are interesting. We know that whatever we do will affect things, and a lot. Our locals are really nervous about what we're doing up here. There's one that's so far out of the box, I don't think we will pass it. There are a lot of ways of killing bills, and I think when we start sorting this out, we can figure out a way of weeding them down to the best ones. I hope we can. Hope we have that amount of time. But my best ideas in my business have oftentimes been the ideas that were well out of the box. But they were also my worst ideas too. So we have to remember that, and we have to, I applaud the Revenue Committee for going through this and helping us with this, but I don't think we'll pass all of them. We can't. A few years ago, we were looking to eliminate every exemption. Now we're looking for new exemptions. So anyway, I kind of think that's my opinion. I believe it might be the opinion of the body.
Representative Pendergraft.
Thank you, Mr. Chairman. I just wanted to chime in a little bit here on the separation according to age and taxes. My kids had to leave the county that I live in because they couldn't afford to live there. I understand the plight of a lot of seniors. My mother happens to be in that category. I also understand the plight of those who are struggling just trying to get a foothold. The idea of taxation, in my mind, should be to make it as fair and equitable across the board as possible. And so whenever I see favoring, I guess you could call it picking winners and losers, and saying, we're going to do something special for the senior citizens on a fixed income. I understand the desire to do that, but I also understand that we need to make this fair. So I guess what I'm asking is, in all of these things, that we take a good hard look at who benefits, and that we do, in fact, try to do some things that are going to benefit the younger folks out there that are trying to get started. And one other just observation, yeah, there are a lot of seniors on fixed income, but there are also a lot of seniors that have done well over the years and have laid in a pretty good nest egg and are sitting pretty. And I'm just asking for caution. Thank you.
Is there any additional discussion on the bill? Question being called. All those in favor of Chairman Harshman's motion that when the committee of the whole rises to report, it do so with the recommendation that House Bill 52 do pass. All those in favor, please say aye. All those opposed? House Bill 52 has passed the committee of the whole. The next bill, division being called. All those in favor, please stand. All those opposed, please stand. Less than 43. I believe we have a quick privilege of the floor. Representative Larson,
Thank you, Mr. Chairman. Privilege of the floor.
please proceed.
Mr. Chairman, members of the House, in our gallery to the back, we have Chairman of the Sweetwater County GOP, Liz Bingham, and State Committeeman Eric Bingham. Please give them a round of applause for Sweetwater County.
All righty. The next bill for our consideration is House Bill 103. The reading clerk will please read the bill.
House Bill 103, sponsored by Representative Allred. Property tax assessment ratio for residential property, an act relating to ad valorem taxation. Mr. Speaker, your committee number 3 revenue, to whom is referred House Bill 103, property tax assessment ratio for residential property, respectfully report same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Bear, Byron, Harshman, Locke, Northrup, Oakley, Storer, Strzok, Swanitzer. Representative Harshman, Chairman. This bill was re-referred to Committee Number 2, Appropriations. Mr. Speaker, your Committee Number 2, Appropriations, to whom is referred House Bill 103, Property Tax Assessment Ratio for Residential Property, respectfully report same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Henderson, Larson, Nicholas, Sherwood, Stith, Walters, Swanitzer. Representative Nicholas, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Harshman?
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report to do so, the recommendation House Bill 103 do pass. It has 2 standing committee amendments, one from the Revenue Committee and one from the Appropriations Committee. I'd move that standing committee amendment number 1 and explain it quickly. Really, this bill's a trigger bill. If the constitutional amendment passes, it'll lower the assessment rate. The prime sponsor can talk about that, but our committee put in the language that it has to be residential property. After residential property, we put for owner-occupied primary residences. So that was the real addition, owner-occupied primary residences. And then the committee put a pay-for in it, so we would make up the difference for local government revenue, and that is $87 million. And then the revenue, or the Appropriations Committee has an amendment as well. So I would move the standing committee amendment. Ask for your aye vote.
Is there any discussion on standing committee amendment number 1? Seeing none, question being called. All those in favor of standing committee amendment number 1, please say aye. Aye. All those opposed, no. Standing committee amendment number 1 has been adopted. Chairman Harshman.
Mr. Chairman, I'd move the explanation over the bill to the good sponsor from this land of Star Valley.
Representative Allred.
Thank you, Mr. Chair. Ladies and gentlemen, I bring you House Bill 103. This is not my bill, this is our bill. Last year, we passed constitutional amendment to separate residential property from the other property that it was being taxed with. I contacted the LSO, and I wanted them to use the maximum, and that's why it changed it from 9.5 to 8.3. So I would, and the amendments have been explained to you, so I would like a friendly, ask for your friendly consideration. Thank you.
Mr. Speaker Pro Tem.
Mr. Chairman, I move Standing Committee Amendment Number 2 to House Bill 103 and ask for your favorable consideration. Members, what this Standing Committee Amendment does is it takes away all the money for the backfill, right? It deletes essentially the $87 million. What it does leave in place is everyone still gets a 12% reduction on their residential property tax, but the money just goes away. And you might ask why we did that. And the reason is that we just spent $123 million on the bill we talked about 10 minutes ago. So there has to be an end to this. So that's there's only so much money to go around. So I'd ask for your favorable consideration.
Chairman Brown, on the amendment.
Thank you, Mr. Chairman. On in support of this amendment, ladies and gentlemen. I think that it's something that I stated yesterday. If we're going to cut taxes, we're going to cut taxes. The state cannot provide all the services to the county and local governments every time we turn around and this body decides we want to make a cut. If you want fire protection, you want water services, you want police protection, you want any of these types of things that we're backfilling already on top of the $140 million we did this year out of this body, we've got to pay for those. That's how we pay for these services. That's how we pay for our roads, our schools. All these things get paid for out of property taxes. And I believe that the chairman of appropriations did a really good job explaining where we were at and how far we've gone down. And now we're going to add another potentially $85 million out of this state's budget. I haven't been here a long time, but I've been here long enough to remember that when we were short in a single year, $360 million. That was 1 year. And we're trying to just reduce that more and more and more every time we walk away, because we walked away with nothing last year. And now we're running scared because we've done nothing last year, so we want to cut taxes for property owners all over the place. We've already done 3 bills. We don't know what the cumulative effect of those 3 are. Plus, we just passed another one through committee of the whole 45 seconds ago. And we have another one here with $85 million. These price tags are starting to add up. We still have services that are critical for our citizenry. On and for this amendment.
Representative Jennings.
Thank you, Mr. Chairman. I don't know. I've been here 10 years. I've seen a lot of spending. I think this time I think this chamber wants to spend about 11.1 or somewhere in that neighborhood. And if not, the executive was 10.8. I don't know. I haven't seen the people and the constituents in my area. It's one of the allegedly wealthier areas. I haven't seen them get that kind of raise. I don't know. I think we owe a little bit to our constituents. And I think the dam busting and the thing of thinking that we're always going to have to cut services every time a snowflake falls onto the ground, nobody's going to be able to drive. I'm kind of opposed to that. The people of Wyoming deserve better.
Representative Larson.
Thank you, Mr. Chairman. If I understand the bill correctly, it's kind of a trigger bill based on the constitutional amendment, which then allows us to segregate residential housing into a different rate. And this would drop that from the 9.5 now down to 8.3. So then you're going to have commercial properties and other properties in there at the existing 9.5. So I think I like this amendment because having the money in there is premature. Let's see if the constitutional amendment passes, then we'll have a legislative session to decide if and what we need to do within those new categories to adjust and perhaps adjust accordingly to where our cities and schools are still taken care of. So I think this okay on the bill, and this amendment just keeps us from committing general funds now until we really see what we need to do. So on in support of the amendment.
Any additional discussion on Standing Committee Amendment number 2? Representative Oakley.
Thank you, Mr. Chairman.
I would urge a no vote on this. We added the backfill to our counties. If we're going to make these decisions, and I agree, we still have some work to do to see how this all fits together. But I think we have to be honest about what the costs are and the revenue and where this goes. And if we do all these cuts but don't give the counties and the cities and you know, special district, all the things that property taxes go to, we're going to be leaving our home communities high and dry. So this is the money that pays for this policy decision. So at this point, I think we need to pony up, and I would urge a no vote on getting rid of the backfill.
Any additional discussion on Standing Committee Amendment Number 2? Representative Zwanitzer.
Thank you, Mr. Chairman. I would suggest that it's not our decision. I believe it's the decision of the voters when they go to the polls, and I think that's something they should keep in mind. If they want to cut, then they have to determine where we're doing it. So I guess there's an assumption that we're going to automatically backfill it, but I don't know that that's prudent to suggest that that's where we're going at the moment. So,
Chairman Brown.
Thank you, Mr. Chairman. We're in committee of the whole, so we get to talk all we want. No, I think it's a prudent question to ask. That's fantastic that the state can backfill this for our counties and cities. What happens when the state can't backfill it? Who's going to pay for that?
Representative Jennings, please exercise your right to talk as much as we can.
Thank you, Mr. Chairman. I will do so. It is our right to do those things, and we have shown that we can spend and that we in the state have the propensity to spend and spend and spend. If we have to backfill and help out our counties and our cities a little bit, then I'd rather see us do that than some of the things that we spend on.
Chairman Zwanitzer.
So the question before you, right, because we can come, if this constitutional amendment passes, we can be back here next year and do anything we want if and when the amendment passes. The question on are we going to fund it or not is, are we going into the election season to the voters on this constitutional amendment, and are we saying if you vote for it, the state government's going to backfill it? Are we leaving the question as is last year, saying, do you think residential should be a separate class? So this adds a whole nother level of complexity, rightly or wrongly, but it's very much tied into the fate of the constitutional amendment, whether you want to tell the voters the state's going to cover it, or whether you want the voters to vote on it independent of the state being the one responsible to backfill. So I would urge you to vote yes on the amendment, leave the constitutional amendment clean. If it passes, trust me, most of you will be back here next year. Well, some of us will be back here next year debating the question.
Any further discussion on Standing Committee Amendment Number 2? Representative Pendergraft.
Thank you, Mr. Chairman. And I'm for the backfill to take care of the essential services. These are the things that government is supposed to do. If it means that in the grand scheme of things, we run out of money to build a brand new museum, celebrate the 250th anniversary of something, all these other things that we were so happy to spend money on, maybe we need to take a good hard look at what is the proper role of government. We do the things that we have to do, we do them well, we do them first. And some of these other luxuries that are nice, maybe we just do without them for a while, because the very people that are supporting us are having to do without for their part. Thank you.
Representative Chestik.
Thank you, Mr. Chairman. A couple of weeks ago, I was able to attend a webinar put on by some of my colleagues at the University over the Hill, where they did a scientific study of taxpayer. It was a representative sample of Wyoming taxpayers, and asked them to evaluate 3 different conditions. The first condition was, are you Are you willing to pay more in taxes to receive more in services? Number two, are you okay with the current level of services and the current level of taxation? And third condition was, do you want tax cuts if that means you're going to have a reduction in services? And the study results were pretty clear across all demographics that the preferred position was we're okay where we are, that we're okay paying the amount of taxes we're paying right now, so long as we get the same level of services from government that we have been getting in the past. What I see this amendment doing is cutting, when you cut the backfill, there's a big tax break on the front end of this, and with no backfill, what's happening is you're cutting taxes, and the lack of a backfill means you will lose services. So that's the third condition, cut taxes and lose services. And that was not the favored position of voters in Wyoming. So I am therefore against this amendment.
Any further discussion on Standing Committee Amendment number 2? Seeing none, all those in favor of Standing Committee Amendment number 2, please say aye. All those opposed, please say no. Standing Committee Amendment number 2 has not been adopted. We are back on the bill. Representative Storr.
Thank you, Mr. Chairman. On and for House Bill 103, this is a great way to consider how to do tax reform. First off, we're going to the public. We're asking them for a vote. We're asking them whether we're going to change our Constitution, whether we want to treat property tax for residences different than the all other category that includes commercial. It also asks the question of whether we think primary owner-occupied homes should be treated differently. It keeps us within the tax system that is meant to be fair and equitable and uniform. If we decide, if the folks decide to vote yes on that question, then should we adopt this bill, we will be treating everyone the same. Everyone that is a primary owner-occupied residence, which we don't have the ability to do right now. And it's worth noting that because we have modified the original bill, this will only result in a reduction to 8.3% assessed value of primary owner-occupieds. That is a not insignificant difference from all residences, in part because of my community. Teton County residences provide 1/3 of the property tax for the whole state. If we take out second homes, especially expensive second homes, then that fiscal note is going to be considerably less. We don't really know exactly how many second homes we have, something we should probably try to understand better. But because of that, this is a less expensive bill than the one we just passed, or the one we'll talk about next. But for those reasons, I support this as the process for going to the voters, asking them what they think, and then making a modest change that helps everyone across the board. So on and for the bill, thank you.
Any additional discussion on the bill? Chairman Zwanitzer.
Hey, thank you, Mr. Chairman. Against the bill in body, we don't need to take this step this year. That's the whole point. With this bill, you're going to tell the voters, we're going to lower it to 8.3% automatically, without a lot of discussion of what's happening to commercial property assessments, if we're going to affect ag, right? Taking residential out of the Constitution to begin with is a very big step. We don't have to make the next decision today, right? We'll be back here in a year. If the constitutional amendment passes, this eliminates the discussion next year, right? We're automatically saying we will reduce it to as low as we can constitutionally right now if the amendment passes. That certainly gives the amendment more velocity, but I'm not sure then it hamstrings a future legislature next year. How are they going to go say, actually, then we're going to raise your taxes to 8.5 or 8.8, right? We don't know what the economy is going to do. You're taking a step way too soon without knowing the ramifications of how everything is going to work after the constitutional amendment, and you're automatically saying 8.3%. And then anything above that will be a tax increase. Nobody wants to do that. So I would prefer you, with all the other options for actual relief this year, those are great. This takes it a next step. You're going to set it 8.3 and you're not going to be able to raise it. And I think that's great for potentially for many of us to go campaign on. I just don't think it's the right step as a legislature for this body to go ahead and enshrine that before we know all the ramifications of how it affects everything else. Your revenue committee or any other committee can spend all your studying what the right tax rate should be, but automatically going as low as possible right now before the constitutional amendment is setting us up to not ever be able to raise that. Not saying I want to raise it, right? I'm just saying this is too early of a time to take this step.
Chairman Washit.
Thank you, Mr. Chairman. I'm just trying to picture why voters would want to vote for this constitutional amendment if they don't have some sense of what the consequence of that vote might be. And so while we may not have the whole picture, when I walk in that booth to vote on this constitutional amendment in November, I think it'd be very helpful if the voters knew up front what we're thinking about in terms of reducing that tax on their residences. And I think that does give the initiative, not the initiative, but the idea of passing this amendment some momentum. But if we don't tell them anything, just say, just trust us, we're here from the government, right? Vote for this constitutional amendment and we'll get back to you. I'm not sure that's a great way to get that amendment passed.
Any additional discussion on the bill? Question being called. All those in favor of Chairman Harshman's motion that when the committee of the whole rises to report, it do so with the recommendation that House Bill 103 do pass, please say aye. Those opposed, nay. House Bill 103 has passed the committee of the whole. Division being called. All those in favor, please stand. Yep, that's what All those opposed? Less than 49. The next bill for our consideration is House Bill 203. The reading clerk will read the bill. I have 20. Sorry. I'm looking online. Just stand at ease, everybody, just a second. All right. Next bill for our consideration is House Bill 203. Reading clerk will please read the bill when he gets to it. We'll give him a second.
House Bill 203, sponsored by Representative Harshman, Property Tax Reduction and Replacement Act, an act relating to taxation and revenue. Mr. Speaker, your committee number 3, Revenue, to whom was referred House Bill 203, Property Tax Reduction and Replacement Act, respectfully report same back to the House with a recommendation that do pass with the following amendments. Ayes, Representatives Bear, Byron, Harshman, Locke, Northrup, Oakley, Strzok, Zwanitzer. Noes, Representative Storer. Representative Harshman, Chairman.
You've heard the reading of the bill. What is your pleasure, Vice Chairman Oakley?
Thank you, Mr. Chairman. I move that when the Committee of the Whole rises to report, it do so with the recommendation that House Bill 203 do pass. And I further move the adoption of the Standing Committee amendment. And I turn both of those over the explanation to the sponsor.
Chairman Harshman.
Thank you, Mr. Chairman. Thank you, Vice Chair. Members, in your tray should be a handout. Just got it in the last couple minutes. It'll say House Bill 203, Property Tax Replacement Reduction Act, and it's two-sided. If you take that, I'd like to walk through that real quick. It explains a lot of the bill, and I think it'll be more beneficial use of our time. So I'm on the back side where it says what the bill does. Does everybody have that? It's in your tray. It should be in your tray. It was delivered to everybody. I'll just pause a sec for. So I think, really like all legislation, it's teamwork, and I'm answering all these emails, and all the Revenue Committee knows what we're talking about, all the emails we received, thousands really, and talked to hundreds of people around the state. And I was talking to a man in early January, first week of January, from Torrington, grew up in Lusk, and we were talking about property taxes, and he's mentioned, I don't own my home, and I got to keep paying this rent. And he said, I'm not anti-tax. I understand, because I says, geez, we went back and forth for 30 minutes on the phone, and I said, it goes back to territorial days when we first had the property taxes, the only tax out there. Ad valorem, those with more land had, more wealth, could pay more, and this whole social contract of building counties and a state and all these services and all those things. He said, I get it. I'm not anti-tax. And I said, well, we're never going to have an income tax. And really our only option is sales tax. And he said, I'd much rather pay higher sales tax. And so in my mind, I was thinking, over $2 billion in ad valorem tax. I said, it might be like 4, 5, 6, 7 cents. But I said, I'll run the numbers on this. So I hung up the phone and I was thinking, a little over $2 billion last year in ad valorem, and half of that's minerals. And then you take out commercial, and so I'm trying to think, maybe it's 3, 4, 5 pennies, 3.5, 4 or 5 pennies, and then it kind of came to me. I remember back working a few years ago, back in 17, 18, and that just 2% of the homes in Wyoming were valued at $1 million or more. So that's kind of changed. So it's not everybody gets the exemption, but if you did it at $1 million, you'd take care of almost everybody. And so I sent that question into our LSO fiscal, how many pennies of sales tax, statewide sales tax, to offset $1 million exemption? Because that's what we're talking about. All the bills we passed are exemptions. We just paid for 2 of them and a tax cut, and we just paid for them out of the general fund. And of course, that's not going to be sustainable, and we're not going to be able to keep paying the one we just passed, and the one before that is actually a 3-year bill, and it goes away. So LSO gets back to me and says, just under 2 pennies. And I says, seriously? I email back, is that still 98% of the homes? 23 CAMA data, 97% of the homes. And I said, well, let's draft that bad boy. And let's start working the numbers on it. So started working through this and went through basically about 12 drafts of it, different ideas, and working through it. And so that's really where this bill came from, a conversation with a man in Torrington. And then I person sent me, and so I just started talking to people. What do you think if we could do no property tax for 2-penny sales tax? And I mean, just started asking people I see around, you know, seriously? Heck yeah. Heck yeah, I'd rather do that. And so that's really all this is. I mean, there's bills coming from the other end of the building. One has a $300,000 exemption paid for by the LSRA every year. So that'll go on for about 10, 11 years, and then the LSRA will be gone. And then we got two problems. You know, you can't pay for the exemption, and your rainy day account's gone. And so, and we're paying these out of the general fund here, but I wanted to find a way that we could pay for it and make it permanent. So that's really the thing, and it's been a lot of teamwork. So working down this handout, here, number one, what does it do? Eliminates property tax for 97% of Wyoming homes. Now most of the $1 million homes are in Teton County. Last I checked, there were like 6 counties didn't even have a $1 million home. But even the residents in Teton County with a $4 million average home now in Teton, 3.9, but let's just say it's 4 million in Teton, they're gonna get a 25% tax cut. And so I think that's important. It applies to everybody. Number 2 on that sheet, it pays for it by raising a state sales tax, 2 cents. And you'll see on the other side of this, I won't go through all of it. I emailed it to you a week ago at introduction, but the bottom line is the average Wyoming family, you're gonna spend $400 or $500 out of this pocket in sales tax, but you're gonna put $2,000, $3,000, $4,000 in the left pocket. And I mean, I was born late at night, but not last night. I mean, that math makes sense to me. And this will be, and I asked our staff, this will be the largest tax cut in Wyoming history. It's gonna put more money in our people's pockets. And we're gonna push a lot of this to the 3 to 4 million visitors we have every year that pay this sales tax. So it's really, and broaden this tax base out. So that's number 2. Number 3 there, property is still assessed. You're still gonna have an assessor. They will go around, you'll still get your assessment in the fall, and all that work continues. Properties, fair market value, all that. If the cap bill passes, you know, it won't go up by more than 5%. And then the assessor and the treasurer will reach out to the state treasurer and say, hey, here in Natrona County, this exemption costs us $110 million or whatever the number is. And then that'll be wired to the county treasurer, and he'll disperse it to this fire district's 3 mills, to the school district's, you know, 43 mills, to the county 12 mills, the city of Casper 8 mills, and the weed and pest 2 mills, just like he does now. Because he just collects a big pot of money right now coming from all of us and disperses it out. So that nothing changes on that. It's very simple. And number 4 there, these things all came from you, and they're basically in the standing committee amendment. Number 1, severance taxpayers are held harmless. That was in the bill, but we're gonna amend that with a standing committee amendment, and a member's got an amendment to even make it a better refund program. We know the mineral producers, the miners, pay about 50%, 53% of all taxes. We want to hold them harmless. So it does that. Number 1 on 4, number 1. And then the governor, this was an idea brought to me. I hadn't thought of it. And we did this in the 90s really successfully when we were transitioning from a 3 to a 4 cent sales tax, and we had a ½ cent for education back in the 90s. And the governor was given the authority that if there was enough money, he could turn that penny down, turn it down by a quarter or ½ penny. And he did that throughout those years through the 90s. And so we've done that before in Wyoming, and it's worked well. Okay, and then number 3, this was brought to me by the representative from Albany County. You know, what happens if the exemption goes away? The Supreme Court or another legislature takes it away and we're stuck with the 2 pennies. And so this is in the amendment, the 2 cents of state tax automatically goes away if for some reason the exemption disappears. And then number 4, under number 4 subpart, the local general purpose pennies can move from a countywide vote to an individual municipality vote. And not to sustain it, take that out with the, and I'll talk about that in a minute, but to just vote. So like Park County, if Powell wanted to have it and Cody didn't, they could go their own separate ways. They're different communities. And now it's currently a county. And so I was trying to, and there's going to be more talk about county, keeping counties with these optional local pennies.
Okay, and then finally, this was brought to me by one of you here on the floor as well. Number 5, the exemption will grow with inflation. And so I worked with LSO Fiscal, and they do economic analysis, and they come with the number that we can grow this at 2% per year and safely cover it with sales tax. And so the charts below there that you see are 50 years, 2074, and you can see the $1 million exemption, the first chart, growing at 2% per year. So in 2074, some of us will still be here, Lord willing. That would be almost a 2.7 million exemption. You know, when I think back, and I wrote in there, my parents' first house in Wyoming was $3,000. You know, someday all our houses will probably be $1 million. But, you know, my first house in Casper was $58,000. So all these things. So the exemption grows to 2.7, and then here's the average Wyoming house below it at 3.9, and that's with Teton added in. So that inflates the average a little bit. It's more around 300,000 without Teton, and you grow that at our 20-year rate, which has been about 3.5%, 4% without the zebra years of COVID, which blew everything up. And you can see that average Wyoming house, which is the high average with Teton, in 50 years, it'll still be below the exemption, still be $500,000 below the exemption. So the idea is you're not going to outgrow the exemption, because sales tax in our state has changed as we've joined the streamlined sales tax states and online sales tax. Oh my goodness. We used to ride sales tax with the mineral industry, not anymore. Out-of-state visitors pay more than our mineral industry now in sales tax. And so you're seeing sales tax steady out and just that gradual growth. So I'm confident, and our staff is confident, and they in fact told me, they said, if you were linking this to any other revenue stream, I'd be a little nervous. But sales tax is really steadied out, and we've given obviously a portion of that to our locals for them because they've got a steady, and as the state rides mainly on minerals. Okay, so that's that back page. If you flip it over to the front page, I think number 1 is really important. We tax about 53 services in Wyoming, sales tax. Go to South Dakota, 150. Go to Texas, 190 services. And so we have such generous exemptions for manufacturing. And so you can see what the effective tax burden is on a Wyoming resident is about $22.40 per thousand income, compared to South Dakota with all their taxation, similar rate, but $31 per thousand income, because they tax everything. We don't tax food, medicine, rent, water, childcare, all these services, legal, all those things. So, you know, you go to these other states. So our effective tax rate's about 2 pennies, 2%. Okay. I already talked about the economic analysis division on number 2. Talked about our sales tax is low. We don't tax groceries, rent, fuel, insurance, child care, prescriptions, water bills. And then number 4 is where the sales tax comes from. Retail trade, half of that is from online. It's incredible. And then number 5, how much is paid by visitors? It's about 13% of the total, 85% of the hospitality, which is the second largest group. And then, you know, I'll just skip down to the bottom, the examples of sales tax rates in the West and the Midwest. And these are combined local and state averages. Now, you know, if you go to Denver, it's not 7.79. You wish it was. It's 10, right? But that's a Colorado average. And Wyoming's is 5.4. If we put in these 2 state pennies, it'd go to 7.4. And you can see we're about in the middle of the pack out of the 50 states. And certainly in the middle of the pack with our competitive neighboring states. Okay, members, that's enough talking. Now I just would like to move through this bill quickly and work the standing committee amendment, Mr. Chairman. And I appreciate everybody's patience with us, and I know we're getting a lot of interest in this bill. And you've all got your steps in going out to the lobby. Okay, starting on the bill, I'll just flip over for a year. over to page 2, I wanted to get this thing going right away, so we grant a 200,000 exemption this year, and it would move to $1 million the next year. That's on the bottom of page 2. Now, this is where, if you have the amendment, lines 5 through 15 on the amendment puts in that growth of that $1 million exemption. Okay, that's on page 2. Then you go over to page 3. We added language, which we did to all these property tax bills on line 8 and 9, that it's the associated residential improved land if owned by the owner. We kind of put that in every bill and had to clean those up in every bill. And then when you go into the bottom of page 3, now you look on line 11, 3915, 104, that's sales tax. It's going to be repeated with use tax here in a little bit. Most of this bill is the sales tax and use tax language coming in. Okay, and that goes to the amendment where it goes on the bottom on line 30. It says 4 cents to 6 cents, and then Romanet 2 on the amendment, Mr. Chairman, lines 37 to 43 says the governor can turn that thing down if he doesn't need it. And then flipping over on the bottom, this Romanet 3 will be on the bottom of page 3, that the additional rate will go to 0 if for any reason the exemption goes away. So that's in the amendment. Now I'm flipping through the bill some more, Mr. Chairman, and I know I'm trying to be speedy, but flipping over to page 4 of the bill, the new language on line 9, this establishes that property tax replacement account in the state treasurer's office. The money will sit there and he'll disperse it back to the county treasurers we talked. The bottom of page 4, an amount to each county to be distributed by the county treasurers in the same manner property taxes are distributed. And so that's in that, and so that I already talked about that. Flipping over to page 5, talks about if we're short for some reason, we'll be proportionally reduced. And then I think that's about all I need to. I'll go down to Romanet 2 on page 5. And this is a mineral tax rebate. And we listened to the mineral companies. They said, we don't want to wait to the end of the year for a rebate. So we put this in there that you'll get it within 60 days. And we gave borrowing authority to the state auditor to borrow from the LSRA. We just copied similar language in statute. So to make sure that mineral rebate form can go right away. And that's the standing committee amendment. I'd like to move that and call for your aye vote on the standing committee amendment. Thanks, Mr. Chairman.
Any discussion on standing committee amendment number 1? Seeing none, all in favor, please say aye.
Aye.
Opposed, no. Standing committee amendment number 1 has been adopted. I believe there's some other amendments that we should probably address.
And Mr. Chairman, I'm done with the explanation of the bill. And I think you all understand it, and I'd love to have your questions. And so I appreciate you. Thank you, Mr. Chairman.
I think at this time we'll address the committee of the whole amendments. Representative Western.
Thank you, Mr. Chairman. I move Committee of the Whole Amendment number 1 to House Bill 203 and ask for your favorable consideration. So this amendment is improving, I think, is certainly upon the Standing Committee amendment, which I think has helped fix the bill quite a bit. Chatting with some industry folks, one of the things that we missed was pipelines. Obviously, part of this whole pitch is that, well, it's revenue neutral for oil and gas on a tax basis. And one of the ones we forgot was the oil and gas pipelines. And so that's what lines 1 through 9 do. As the good coach mentioned, some of those extractive industry companies were worried about having to wait all year. So all this cash comes out of their pocket and they don't get it back for quite some time. The amendment we just adopted shrinks that down to 60 days, but just to help give some additional assurance and allow some of those companies to get that money right back onto their balance sheets, we shrunk that down to 30 days, which the amendment does in lines 11 through 16. And the last part of the amendment is lines 17 through 21, and what it basically does is it increases that borrowing amount just to make sure in the event that the extra money is needed for that kind of temporary bridge loan. So that's what the amendment does. I think it makes it better. It was formed in consultation with some of these industry folks. So please vote aye.
Discussion on Committee of the Whole Amendment Number 1, Vice Chairman Larson.
Thank you. To the sponsor of the amendment, I'm not quite sure that I understand when we say who is an oil and gas company or who is an oil and gas pipeline company. So that's a little wonky. Maybe I'm just trying to understand. So are you saying if you're an oil producer and you have infield pipeline gathering systems, that then you're a pipeline company? Or are you referring to like a midstream who is commercially selling, that goes and buys the product, who doesn't pay any severance on oil or gas? The only taxes they're paying is real property taxes and sales tax, and now we're going to say they're exempt, or they get a refund on the sales tax? Is that what we're saying here? And how about interstate? Now, if I could get clarification on that, it's a little ambiguous to me.
Representative Alaman.
Thank you. My concern is I'm not sure whether CO2 is an element of gas. If it is, I'd be very against this amendment. If it's not, I'd be for it. But I don't know what it is.
Chairman Harshman.
Thank you, Mr. Chairman, and I appreciate the questions. And there are two NAICS codes, and I'm looking for them. I can't find them right now, but there are two NAICS codes, NAICS, which defines sales tax. And there are one for oil pipelines, and we're talking about the purchase of the pipe to lay in the ground. So we don't want to increase the price to build energy pipelines in Wyoming. That's what this is about. And then the other NAICS code is for natural gas pipelines. That's all this is. And the Department of Revenue, we can work with them on the deal. So, and maybe we need to clean that language up a little more and add the NAICS codes. We sure can. So thank you, Mr. Chairman.
Representative Davis.
Thank you, Mr. Chairman. Question along those lines for the good bringer is that intrastate or in-state pipelines that we're talking about here?
Chairman Harshman.
It's a very good question. And part of the interstate, our sales tax state compact is, it's like your automobile. It doesn't matter where you buy it in these compact states. Maybe you're not charged sales tax there. It's when you come back and register it in your county, you pay sales tax. So they could buy this pipe in North Dakota, and they're installing it. And once they hit the Wyoming line, every foot of pipeline in Wyoming pays the Wyoming sales tax, not North Dakota sales tax where they bought it. So while that pipe is in state, that we're talking about the purchase of the pipe, not any, because none of the services are taxed, right? It's just the purchase of pipe that goes in the ground. So every foot that's in Wyoming gets taxed. And this would be an exemption for those extra 2 pennies to hold them harmless. We don't want to increase the prices for our mineral industry on this. So, and and it's a small amount, I'll be honest with you. I mean, a small amount in the numbers we've been talking about. It's not like millions and millions and millions of dollars each year. Some years you'll have a big spike with a big project, but it can be easily folded into this. So thank you, Mr. Chairman.
Is there any additional discussion on Committee of the Whole Amendment Number 1? Seeing none, all those in favor of Committee of the Whole Amendment Number 1, please say aye. Aye. Opposed, no. Committee of the Whole Amendment Number 1 has been adopted. We are now on Committee of the Whole Amendment Number 2. Representatives Wanitzer Dave.
Thank you, Mr. Chairman. I move Committee of the Whole Amendment Number 2 to House Bill 203 and ask for your favorable consideration. So, ladies and gentlemen, I was kind of excited to hear an out-of-the-box thought process, and I applaud the bringer for bringing this. But I'm talking back and forth to myself and can't decide how well I'm able to give this off to my constituents. So what this amendment does, it sets back the initial date from January 1st of this year back 2 years. So it would allow the bill to move forward, but it would give us a year or two to go out and actually see what our constituents think and believe. Now, I would suggest to you, some of you probably have received some comments on this bill, and usually the first comments that come in are very non-positive. But sometimes you need a little bit of time to think, churn it over. And so all this amendment's doing is setting this thing back a little bit, keeping it on the table, bringing it out so we can have some talks with our constituents, let them have a couple nights to sleep on it and see what they come up with. And with that, I stand for any questions.
Chairman Harshman.
Mr. Chairman, you know, and I appreciate the bringer. He came to me talking about this, and other members of the floor have talked about this. I don't have a problem with this amendment. I think you think about what you've been through out there in the lobby, and because the whole idea is to keep the status quo, right? That's why you're being, that's the way it works. And boy, I think the people of Wyoming don't want us to keep studying this forever. And so this amendment keeps this bill moving forward, pass it into law, but we can study it while the airplane's taking off, is how I kind of see it, and go from there. So I'm not opposed to the idea at all. It's probably a good idea, and I think the good representative that's going to maybe speak next talk to me about this as well. And then, so I appreciate the teamwork on this. Thank you.
Representative Davis, and let's keep it on the amendment, at least for the time being.
Thank you, Mr. Chairman. I hope I'm not in the plane when the wing falls off, but is this amendment basically wants to put this back into the interim as an interim topic, I guess, is that the basis of this amendment?
Representative Alaman.
Thank you, Mr. Chairman. I urge a no vote on this amendment. The people in House District 58 need this help now, not in 28. They need it this year, starting July 1st. Thank you.
Representative Larson.
Thank you, Mr. Chairman. I think the conversation on this whole taxation, particularly property tax, is interesting. What I hear from my part of the world is we hate our property tax, we don't like it. Now we're hearing, but just don't change it, right? And I think we've got an opportunity to really, when I first heard this idea, you know, it kind of sets you back and you say, I don't know, 2 more cents sales tax, is that really what we want? But you know, it's kind of an acquired taste, and pretty soon it tastes pretty dang good. And I think it's one of the greatest ideas that on taxation, and it fits. Now, whether we should adopt this amendment and move it back, it gives me a little pause, because I think right now, I mean, this goes in for biennium, but we could get instant relief even this year. And I know that I just think that it's really an opportunity to fix our broken tax structure in the state. So I prefer to just move it on, and would prefer opposing this amendment, but let's keep this thing alive.
Representative Locke.
Thank you, Mr. Chairman. On this amendment, I'm not going to speak, well, I will speak to the amendment. The one piece to this amendment I will just put in everybody's mind, keep in mind, this is it's a big change. There's 2 sides of the big change, right? This isn't just a forklift change. This is a sort of a completely revamped change. Keep that in mind as you think about this particular decision. And keep in mind on the other side, I know it's the bringer of the bill, because quite frankly, I think it's a great concept. I, of course, have my questions as well, but considering this amendment, keep in mind, it's a very significant change. On the other hand, we do have to be bold, so I just confused everybody, and vote your conscience.
Representative Western. Chairman Harshman. Anyone else want to speak on Committee of the Whole, Amendment number 2? Representative Zwanitzer.
Thank you, Mr. Chairman. It was just my attempt at a compromise, ladies and gentlemen. I think we all know this has some merit, correct? If you're going out to buy a new vehicle, maybe not so much, but if you're planning on sitting home reading books for a year, it might work out pretty good. So vote your conscience. Thank you.
Any more discussion on Committee of the Whole, Amendment number 2? Seeing none, question being called. All those in favor, please say aye. All those opposed, no. Committee of the Whole, Amendment number 2 has not been adopted. We are back on the bill. Is there any discussion on the bill? Representative Yin.
Mr. Chairman, thank you. So I think some of you might have wondered, why isn't there a sunset amendment on all the bills that we have been doing on property taxes in Committee of the Whole? I am going to bring it on second reading for this bill and the other ones. I wanted to make sure that we have this discussion, especially for this one. This is, as the good coach from the center of the state called it, a bold new change, and as well as the other representative from the center of the state called it, it is bold, but it's a big change. So I do want us to talk about it and have these conversations about it, knowing that this is going to be a permanent change, thinking about it as a permanent change. But I still think that we need to put that 3-year sunset just so we can have that conversation, and I'll bring it on second reading, of making sure that we do study the plane as it's flying, and I hope that the good bringer will support it too when I bring it on second reading.
Representative Conrad.
Mr. Chairman, thank you. I just want to credit the desk mate of mine for the miles he's put in walking these House floors, but most importantly for the 8 hours he's coached me on this bill and how I should vote. But with respect to that, I want to share with you, I have significant concerns with this, ladies and gentlemen. There's a multitude of issues, at least in the southwest corner, that we need to be cognizant of. First and foremost, how does this impact our industries, our extraction industry, et cetera? And I'll just share with you just a few that I've commented here. Short-term cash flow issues while waiting for that reimbursement, whether it's 10 days, 30 days, potentially even 60 days, that's an impact of the business and our operating plan. And making day-to-day operation decisions may be more difficult in this case because it also impacts our purchasing decisions. How about these investments in new pieces of equipment or bits, mining belt, et cetera, so forth? We've talked about it. I think the good speaker or the good chairman, or in this case, coach, Representative Coach, has talked about the availability of funds and how those will be refunded. You know, I also worry about sales taxes for our vendors. How does that impact those and as we get the values? But I want to share with you one last comment. One of the areas I haven't been able to overcome, and maybe I've missed it, if those folks who are living in a rental home or assisted living or an elderly couple go out to dinner or buy something, it's going to be 2% more, right? Do they reap the benefits of the property tax when they're renting or an assisted living? I don't think they do. And the final conclusion that I share with you, and I'd ask you to consider, for myself, there are 4 components of taxation. Is it justifiable? You'll vote accordingly. Is it equitable? That's highly debated. Is it stable? Well, as we heard before, it could be in perpetuity. And lastly, is it transparent? Probably is. I have significant concerns, and I'm a no vote, and my good colleague and coach, and I'll leave it at that. Thank you.
Representative Stiff.
Mr. Chairman, thank you. I encourage a no vote on House Bill 203. It looks great. It's a nuclear bomb to property tax. It's $1 billion of less property tax in a biennium. It's a huge amount. It's a big idea. So a couple of things you already know, of course, is that it is regressive. It means when you go to buy your vehicle, on a $50,000 vehicle, you're going to pay an extra $1,000 in sales tax. You know that already. The other thing that you all know already is that it makes our revenue streams to our governmental entities just more volatile, right? We talk about volatility. But I'd like to spend most of my time actually talking about a pretty significant unintended consequence of this bill. And it relates to the fiscal note. You've probably seen the fiscal note. It's worth looking at. You'll notice on the fiscal note, again, it's fiscal year 25, it's about 480 million, then 492 million, then 500 million in the third year of this. But the line item that I think is really interesting to look at, and for you to take a deep breath before you vote aye on this, is the local taxing entities. You see, the local taxing entities, when this gets fully implemented, it's about $172 million going up to $177 million of lost property tax. So let's talk about special districts. We have over 600 special districts across the state. It turns out that collectively, they spend more. They actually spend more than all of our municipalities combined, right? Little known fact, right? It's a big number. So they're part of that 172,500,000 in the fiscal year 26. In fact, they're a huge chunk of it. Don't have the exact dollar number of it, but it's probably half. It's a big number. Okay. So what are these special districts? Well, they're really useful special districts. It's when landowners get together and say, we're going to tax ourselves so that we can do some improvement that we need, right? There are a lot of them, and they're good things. For example, and for the most, there's, just to go through a couple of these, just for fun, there are cemetery districts, flood control districts, fire protection districts, sanitary improvement districts, special museum districts, solid waste disposal district. These are all good districts, okay? Almost all of them have a maximum mill levy they're allowed to charge. So if you're a cemetery district, 3 mills is the most you can charge. That's it, okay? To take a sanitary improvement district, it's 1 mill. Hospital district, 6 mills. There's one kind of district, strangely, that has no limit. It's called a service and improvement district. And our highest court, and yet another case that I lost, okay, it's kind of ruled that service and improvement districts have unlimited taxing power. Very bizarre ruling in my view, but that's the law right now. You may want to think about changing that. In fact, you had an opportunity. Well, anyway, okay. So here's the problem with this. The fiscal note is accurate as a snapshot of the situation today. It's accurate. It really is. Our staff does a great job. It's accurate as of right now. But there's something called the principle of using other people's money that's a real strong, powerful motivator. What really keeps a lid on these special district taxes is that the landowners who are in them have to pay them themselves. And so it happens a lot that, say, for a cemetery district, they don't assess the full 3 mills for the cemetery district because they only need 1.5, right? For the hospital district, they may not need the full 6, so they assess 4, right? Service and improvement districts may assess 6, 8 mills, right? But what happens when this bill becomes law? Suddenly, you can increase your mill levy to the absolute maximum, and guess what? You don't have to pay for it. You can increase your special district maximum mill levy to the absolute top, and other people pay for it, right? So this number of 172 million is very, very likely to increase, because if you're a special district, what do you want to do? I'll think, well, gosh, we've been living on 8 mills, but wouldn't it be nice to assess 12? And you can vote for 12 and you don't have to pay for it, because the people paying for it are going to be the people paying sales tax, okay? So this line item is very likely to increase by some unknown amount. That's the first problem with this special districts. The second problem with special districts, and this actually would help me, so please, if you vote aye and this becomes law, I will be very happy, because I've been trying to fix a flood control problem in my community for a long time. Flood control districts can go up to 12 mills, 12, right? Okay. So if this becomes law, I want to get a special election in as soon as I can to create a new special flood control district, levy 12 mills, which in my county raises $36 million a year, and in 2 years, I'll have $72 million to build a levy. Okay, you say, well, we'll fix that. We'll amend this on third reading so that you can't do a new district ever again. Well, what does that do? That really chills creating any new special districts, okay? There are unintended consequences here so, and you say, okay, fine, nice technical argument, but you're being far too, cute. Maybe you don't like the argument, right? We'll just deal with it when that happens. Well, then what happens is, because there's not enough money to go around with 2% sales tax, this refund to the minerals industry doesn't happen because there won't be enough money to go around because the special districts will be sucking it up. So that's the unintended consequence, and I can't think of a way to fix it on an amendment. And the reason you can't fix it with an amendment, I don't think, is because you can't fix someone's desire to spend other people's money. Thank you.
Chairman Harshman, I'm looking forward to your
Yeah,
response.
thank you, Mr. Chairman. I appreciate the good country lawyer bringing this up. And like all stories, there's more to the story. And we do have 612 taxation districts in Wyoming. And then you take out the 23 counties and the 99 municipalities and the 43 school districts. So you're down to about 400. And, so nearly all of them are at the maximum mill levy right now. And then many, many of them are fee districts. I belong to a fee district. I have to pay a couple $100 a year to my association to grade our road. It's not on the mill thing, but it's in this taxing district. Okay, so many, many of these are fee districts. And so I think, just back up a minute. $1 billion in a biennium, nuclear bomb. I mean, come on. I mean, this is pretty straightforward. And I just want to finish with, all of these districts are governed by statute and law, and every one of them have required a vote of all the people. Now, if you want to do a 12 mil flood control in Sweetwater County, the industrial folks will have something to say about that. I'm sure your mineral folks will have something to say about that. I'm sure the commercial guys and maybe the ag guys will want to weigh in on that too, because they're impacted by that. They're not exempted like homeowners. And so that's going to be a bigger discussion. It's not just like, hey, vote for this, somebody else is paying. Because the Trona producers in Sweetwater County will pay 12 more mills. Well, good luck running that one in your local community. And I just don't think that bird's going to take off and fly. And so I think, again, most of these are maxed out. And then many of them are fee districts. And finally, many of them have agreements written in that where they stuck the mill levy goes with a budget. And these are elected boards that they can't go over the budget. Now, not all of them, but many of them are like that. And like, there's cemetery districts that are allowed 3, some of them are like at 0.98, a couple of them, because that's what they agreed to the voters, to have a mill of 0.98. So but I appreciate the good representative from Sweetwater bringing this up, because that was literally in like my versions 2, 3, 4, and 5 of this. It's a big deal. And I tried at first to limit mills and then to say where these mills. And then you got to kind of think about, is this a big deal or not? Am I making the important stuff important or not? And it's not that big a deal. When you look at what's happening on the ground, it's not that big a deal. The bill states, though, that in 2026, any more bonded mill levies where you want to build a new rec center in your town or add on to your school, those will not be reimbursed in this bill. And in more to that story, the Department of Revenue's new computer upgrade, right now they can't divide those out, but they will be able to, and that's why it says on page 5, lines 14 through 16, beginning in 2026, these bonded mill levies won't be a part of this. But I really appreciate you bringing up that straw man. I hope I've lit him on fire and he's burning right down here in front, and we'll move on to the next issue. So thank you, Mr. Chairman, respectfully. Appreciate that, Mr. Speaker Pro Tem.
Representative Tarver.
Thank you, Mr. Chairman. I want to thank the bringer of this bill. As I told him previously. I think this is thinking outside the box big time. And I believe we should take a deep look at this. I do not believe this is the time to move this bill forward. I'm just going to bring up one unintended consequence. And I was looking through this sheet, and I got down here looking at the states, and I couldn't find Montana, so I had to scratch my head a little bit. So all the northern side of this state is going to have a massive impact because they'll just go a little bit further to the north to do their purchasing. And this is a major unintended consequence that I think needs to be looked at hard. Thank you.
Representative Alaman.
Thank you, Mr. Chairman. This is big. It is bold. It is not a nuclear bomb. It's a firecracker. Where the nuclear bomb comes in is when our constituents open their property tax bill. That's where the bomb comes in. Folks, this is my lifelong dream, I guess. I think property tax is immoral. Immoral, I believe. This, if you make the money and can afford that new Jaguar, most of my people are paying $3,500. That would be a Jaguar, not a Hyundai.
No proper names on the floor, Representative Alaman.
I'm sorry. It would be a luxury car, not a minivan. I urge a yes vote on this bill, and I think when you go home, I've heard from many of my people, the tourist industry in 2021 was right at $4 billion. That's $80 million that your constituents don't have to pay. And I think there is so much economic development in this because when people all of a sudden own their homes that the county doesn't, they may put in a new bathroom. So they go to the lumber store and buy a new toilet and a shower and shelves, and they're paying property tax, or they're paying sales tax. I'll get it right. They're paying sales tax on everything they buy. But they're bringing it home, and it is actually theirs. It's not the county's. Thank you.
Representative Pendergraft.
Thank you, Mr. Chairman. Folks, I'll be brief. A lot of discussion, a lot of moving parts, a lot of things to think about. There are a lot of things in this bill that I like. There are a few that I do not like at all. And so at this point, I would be a no, and I would urge a no. I would encourage a no vote. This seems like an ideal subject to take up in the interim and to be able to break down and take a good hard look at it when we have time. This was brought up to us relatively recently, and we just frankly haven't had the time to digest all of what might come into play here. So again, I'm a no, but I would love to see this explored a little bit further. I have some ideas of my own that I'd like to share. I just think we're going to move a little bit too quickly.
Representative Storer.
Thank you, Mr. Chairman. One of my colleagues from the middle of the state suggested I was vertically challenged, so I thought I'd try this higher podium here. Let's see if I can. With all due respect to the good chairman of Revenue Committee, I just want you all to know that this is not an idea that we took up in the interim. We have not studied its unintended consequences. We don't know how it's going to impact different states, different counties. We don't know how it's going to impact special districts. We don't really know how it's going to impact industry. We don't even know whether it's constitutional. And I think there's actually a good argument that it's not. Giving a $1 million exemption to the tax that is the basis of our wealth, the basis of our system since we became a state, is something we should take time to consider. It is something that we should be thoughtful about. It is something that we should consider all the consequences to before we move forward. Tax reform should help broaden our tax base, not narrow it. It should make it fair. It should not ask too much or more of those who can least afford it, which is what this bill will do. There are just a lot of questions out there, and I've heard them from lots of people from all walks of life. And I just don't think we're ready to take this step at this time. We've got a lot of other bills out there to parse through. I think it's time to consider this one in the interim, consider it over a period of time, and let's just figure out what we can do now that we actually can understand. Thank you.
Representative Locke.
Thank you, Mr. Chairman, and a couple of items, or you guys know me, I'm the guy who's always trying to do property tax relief, so I know there's only 61 people in this room that I hate hearing that, or more. Anyway, that being said, that's the shiny object here, and I just want to make sure everybody understands that we've got to go beyond following the shiny object, okay? Because believe me, removing property tax, I would love that too. I just want to bring up some of the issues, and they've been kind of brought up in bits and pieces. A previous speaker was just talking about the concept of the sales tax, and we did ask the question in committee of the sales tax, and I asked this concept. I said, hey, when you did this sales tax, you added 2 sales tax on. Did you take a linear approach to that, or did you take a look and say, hey, if we raise it 2 cents, does that modify our people's behavior? Does that modify people's behavior in the state? The answer to that was no, they hadn't taken a look at that. Those are some of the concepts I want you to keep in mind. Second, some of the other concepts, and I know that one of the previous speakers did a great job talking about the concerns from some of our, our minerals and our oil and gas and that kind of thing. Well, just so you know, all of those people, the bringer, by the way, did a great job of trying to look at, I shouldn't say it that way, but did a great job of looking at where he thinks they're going to be adversely impacted. So he's looked at some of that. And so I think that's great, and it's a great step in the right direction. But keep in mind that those operations and how 2 cents of sales tax may impact them can be significant. And I wanted to bring this up because this was made clear to me, at least in terms of some of our minerals. Now, I know there's plenty of people in this room, and I guess what I'm asking all of you to do is go back to those people in these industries and ask them these questions and take a hard look. But we have some minerals in this state that we're in very close and narrow competition with countries like China, right? It's a great idea. Do we know how 2 cents, this 2 cent tax, impacts that competition? I would argue maybe the analysis has been done. I suspect in the amount of time we've had to do it, I would say no, but I do know those industries have concerns. So I want to raise some of those issues, and those concerns and issues exist. We've talked about 8 or 10 of them. Again, I think the bringer did a great job of digging into a lot of the major complex issues. That being said, for the 8 or 10 we did, there's 1,000 others that we just need to take. I ask all of you, the people in this room, people who can help us do this analysis, get involved. I'm just asking you to think through all the issues and take a holistic look. Caution with chasing the shiny object. Thank you.
Representative Davis.
Thank you, Mr. Chairman. As I'm looking at this bill, it says right there, in act relating to taxation and revenue, establishing a property tax exemption for single-family residential properties, correct? Okay, we have, over in our area, we're very dependent upon ad valorem tax from the industry. Ad valorem, it generates a lot of revenue over there. Is that addressed in here? Because I don't find it in here, is the big question I have. And then over there, on your discussion about the residential property, you have a description in there that was a little bit confusing to me. That says, privately owned single-family dwelling unit and associated improved land. is that 5 foot away from the foundation? Is that an acre? Is that 40 acres? I think we need to be a little more descriptive in there. Okay, thank you.
Chairman Harshman.
Thank you, Mr. Chairman. I appreciate those questions. That was a broad topic of a discussion in the Revenue Committee on every bill. And so you're correct, that definition and the language that was recommended to us by the assessors, Department of Revenue, the people who are doing this work, is the associated residential improved land. And that is different in every situation. You know, you might be on a farm where it's an acre, might be 5 acres, might be 10, might be 45 acres of residential land. And so the assessor works with that property owner. It's different everywhere. And so some of these bills came to us, had 1 acre. Some had 5, some had 45. And so we cleaned all those up with this similar language in all the bills. Your first question was about mineral taxation, ad valorem on minerals. So we have our property tax classes in Wyoming are minerals assessed at 100%, industrial 11.5%, and all other. This only takes, and all other is ag, residential, and commercial. This only takes a little exemption on residential. Doesn't affect any mineral company, no rate, no tax thing on them. Nothing changes in property tax. Nothing changes in property tax for anybody. It's just we pay for an exemption for all our homeowners. So I hope I answered it. Did I answer that for you? So if you look at your tax bill and your taxes, your home's valued at under $1 million, you're going to be exempt. And we're going to pay for that by sales tax. And you live down by Colorado, you know it's several pennies higher than your hometown when you know, if you go down to Craig, no doubt about it. So,
All right, Chairman
thank
Harshman,
you.
I'm gonna
Yeah,
move
yeah.
on to the next speaker, and maybe you two can sort it out offline. Representative Penn.
Thank you, Mr. Chairman. Talking about unintended consequences, I have a good chunk, probably half of my district that doesn't pay property taxes and on the reservation. And so for this 2% increase on sales tax, now they don't pay sales tax on a lot of things as well, but if they go off the reservation, then they'll be getting hit with this 2% sales tax. I would love to sign up for getting our people $1 billion of tax relief, if that's what the number is. I'd be the first person to sign up for that, but if this is a good idea now, it's gonna be a good idea later. So I would say let's, I don't want this to be a situation where we say we have to pass the bill to know what's in it. Let's give this the time that it deserves. We've had 11 days to look this over. Our citizens and the stakeholders deserve more time than that. Thank you.
Representative Singh.
Thank you, Mr. Chairman. Broadly speaking, I appreciate the concept of reducing property taxes to zero. That sounds like an awesome idea. However, I'm worried about when it says that we'll take $500 out of the hands of the average Wyoming family and put another $2,000 to $3,000 into their pockets. For those that don't have the luxury of owning their own property, for those people that rent the place where they live, that's taking $500 out of their pockets and replacing it with nothing. People that are having enough trouble saving enough money to maybe achieve that dream of owning their own property are instead asked to give up some of that so that other people can experience that relief on their behalf. And so I'm on the fence on this bill right now, and I'd like some reassurances on those questions.
Representative Obermuller.
Thank you, Mr. Chairman. Now, I have a lot of problems with this bill, but I know everybody kind of wants to hit the road. So I'm just going to bring up one issue right now, and perhaps there'll be more in the future if this moves forward. But we were told that that this 2-cent sales tax would be paid in large part by out-of-staters. The 50% increase in sales tax, and the out-of-staters are going to pay it. There's just one problem. All that money goes into the pockets of homeowners. Remember, that's part of that big balance. You know, here's the sales tax, here's the property tax, one-to-one relationship. So all the work that we're gaining out of our out-of-staters is going to one group. So it raises the issue of the large of one tax that covers this group, funding a smaller group of our citizens. Sales tax has always operated as a general fund benefiting the entire state, all our people, and we're doing a 50% increase that's going to benefit less than half of the people of the state. So think about how we use sales tax and whether this is consistent with that. So this is a bill that I like personally, but I'm a representative, and I just don't see that benefiting everybody the same way. So that's my problem. I think we take it into interim. I agree with that concept. I'll be a no.
Chairman Harshman.
Thank you, Mr. Chairman. Just real quick on the renter, both the last two speakers kind of brought that up. So the renter number, it's just under 75% of the households in Wyoming own their own home. So it's about 23% our families are in rentals. So that's an issue. And I think, this bill had a rental refund in it and earlier versions, and it's just hard to figure that out. And if you've got an idea for that, that's great. But I think the biggest part of this is it's going to lower house payments. You're not going to have these escrow payments of $200, $300, $400 a month for property taxes. And so it's going to allow people to get into homes. And so I think that's part of the story too. So thank you for those questions on renters.
Chairman Eklund.
I'll be as quick as I can. So this one's way out of the box, and I think we all know it. And like I said, sometimes those are the best and sometimes they're the worst. We're already the lowest tax state in the country, except maybe one that's way up there by the Arctic Circle. But that's according to the most conservative think tanks in the country. So we have to be kind of careful. I don't know, I think it is a nuclear option. And I want it to go into interim, and I may if I vote an aye, it's because I want to see it advance and more discussion on it, even though we don't have time to discuss things this budget session. That's a problem. But if it goes into the interim, I'm not sure we can sort it out even in one interim. It may take several years to figure it out, but it is really a good idea to explore these things and try to figure out how can we get a lower tax for our people than we've already got.
Representative Ward.
Thank you, Mr. Chairman. I'm generally disposed to vote aye on this, but I do have a question for the bringer. First off, I like that everyone's got skin in the game. So everyone has an interest in what happens with our state. And you can decide to pay more or pay less based on what you buy or you don't buy. So when everyone has skin in the game, everyone will pay attention to what happens in the state, and they'll participate, which is a good thing. My concern or question is, when it says eliminates property tax for 95% of Wyoming homes, it's got a $1 million exemption. What happens in the future if, or even on second and third reading, that's amended down to 500,000, 200,000? Can the bringer give me some assurances on that?
Representative Knapp.
Mr. Chairman, thank you. That man in Torrington that said, I'm not anti-tax, I'd like to meet him because most of the people I talk to are anti-tax. This is important. It's an important subject, and this isn't something new. We've actually seen this before. A recommendation of raising sales tax and reducing other taxes, or raising sales tax just to get that income stream. So it's an interesting idea. But I go back to, this is such an important topic. You want to talk about hearing from your constituencies? This isn't 30 or 40 emails that you get from people. This is major industry, oil and gas, Cole, the association that covers our taxation, the county commissioners. These aren't just people, these are major, major parts of our constituency in the state of Wyoming. Some who pay over 70% of the tax currently, who are saying, stop, get this to interim. It's an idea, it's worthy of working through, but you don't necessarily have to have a bill to do that. So I would say I'm against this measure. Get it to interim, get all the parties involved that need to talk about this, because this is a total change of the tax structure of the state of Wyoming. You don't see a doing away of residential property tax. In fact, we heard all the work still continues. All the assessments still continue. In fact, there's extra steps in this to get the people their rebates and to still have a functioning assessment process. So this is a big change, but with all the same work. So I do think let's get this to interim. Let's talk about this. Let's not get on a plane where we don't know where it's going. There are so many unintended consequences of this, even in the tourism sector. Looking at the sheet that we were giving, basically, I looked for the things that weren't underlined and weren't bolded, which is saying we're one of the lowest taxed states in the nation for sales tax, which to me means we're about ready to jump into the sales tax arena. There's now 7 states that are going to be cheaper than us in sales tax. What does that mean for tourism? Does that mean the states around us that are also not as beautiful as Wyoming, but that are also beautiful states to go visit, will they receive more tourism because their taxes are lower? There are so many unintended consequences to this, I think that an interim is appropriate.
Representative Henderson.
Thank you, Mr. Chairman. You know, folks, I'm getting a lot more than 35 emails about this, and for most of them are in favor of it. At least giving it a chance in the process for us to come with our best ideas relative particularly to business and to perhaps some of the unintended consequences. That's what we do in this legislative process. The sales tax, as mentioned earlier, is the choice tax. It's a choice tax. You choose to go and spend. Now, businesses don't have quite as much latitude, but I think we can look at ways to consider as we go through the process to perhaps offset some of that concern. The concern mentioned about up north, to the border with Montana. We have that problem down here with Colorado and some things. But, my first bill was lodging tax as a eclipse. And I wanted to get a piece of the wallets, the million people that came in here for that eclipse. Didn't get it through, but when we finally got it through, look what good has come out of that. Tremendous good. And it's a process of everybody working together for common good and moving forward. I think one of the fundamental things that this will benefit are our seniors and people on fixed income. It'll also be a way to provide younger people, those who are trying to buy their first home in their mortgage, a few $100s break, right, for their day-to-day expenses, to help them better meet their bills. So I think it's worthy of discussion. If at the end of the day on the third reading, we're not there yet, we can pull the pin and come back and discuss it. But good ideas will rise and fall on their own merit. And we don't get everything right the first time through. I'd urge an aye vote to get it introduced, and let's work it on second and third.
Mr. Majority Floor Leader.
Thank you, Mr. Chairman. As your floor leader, I've been watching the clock, and we are now at 1 hour and 7 minutes discussion on this one bill. And in what short tenure I have here, that tells me that this needs more work and it needs more time to be addressed. I will be a no on this. I was a yes to introduce it because I wanted to be able to hear this discussion, but I will be a no on this because I do believe there are so many working parts to this. The people of the state of Wyoming and this idea need a chance to be vetted and thoroughly worked through. So my admonition to you is, and I know everybody's getting tired because I'm watching as bodies are starting to drop below the level of their names. I would encourage you to, let's move this up or down, and let's go on, because we've got some things we need to deal with here before we close this out. So that's my admonition. Call the question.
Representative Western.
Thank you, Mr. Chairman. I know the hour's late, and we've been talking about this a lot, but I've got some thoughts that I would really like to share, and I ask for a little bit more grace and your indulgence. As you all notice, I'm a co-sponsor on this bill. I'm not going to break it down. The good coach did that. But rather, I'd like to share a few thoughts on what this bill ultimately represents. Many of you have mentioned how you really like this concept, but you have reservations. It's not fully vetted. It's too rushed. It's something that should be worked in the interim. I submit to you all that the topic of tax reform has been worked countless times during the interim of the past 20 years. Thousands of committee hours have been committed discussing tax policy of the kind this bill deals with. You'd think we'd have something to show for it, but we don't. This bill is an opportunity to do that. The lobby outside is full of people who have encouraged you to vote no. And to be clear, I don't blame them. They're paid to do a job and to do so with their best efforts. But if you'll hear me out, I'd like to explain the other side of the coin. I'll be the first to admit this bill isn't perfect. For example, there are plenty of exemptions not included in the bill that would otherwise broaden the tax base. I certainly hope we can get to this next session. What the bill does is pretty straightforward, but what the bill symbolizes is of the highest importance. At a fundamental level, this bill is an opportunity for us to have a stronger, more economically secure future because of our reliance on extractive industries for revenue remains one of our biggest weaknesses. Sometimes I worry the legislature gets too caught up in the minutiae of government, that we don't take the time to stop and think. In my short tenure here, I worry we don't think big. We don't dare to dream about the sheer magnitude of what we can become. When I first arrived in the legislature, I didn't fully understand the connection between economic development and tax structure. And to be sure, I still have much to learn, but of this, I am sure. Without reforming our tax structure and directing that revenue to strategic investments, which will help diversify and grow our economy, we will never realize our full potential. There has been almost no significant change to our tax code in nearly 50 years, and this bill is our chance to take a step in the right direction. This is why this bill is so much more than just a question about tax reform. This measure is asking us to reach deep down inside of ourselves and muster the strength to look upward and ask, what future do we want, and who are we going to be? In a sense, this measure is a renewal of our commitment to the great American experiment. This measure is a renewal of our commitment to ourselves and to our future. If we close our eyes, we can see that future. One where our communities are full of our kids achieving their full potential. One where those kids are driving research and innovation and creating a strong and robust economy full of opportunity for all. For like America, this is what Wyoming is about. It is the uncrossed desert and the unclimbed ridge. It is the star that is not reached, and is the harvest that is sleeping in the unplowed ground. I truly believe that like America, Wyoming is the land of opportunity. But nothing is guaranteeing that it will always be so. When I look up into the Wyoming night sky, I see no indication that a higher force will come and save us from ourselves. The thought of a Wyoming future that is handcuffed, unable to bring about our best selves and achieve what we are fully capable of, is one that overwhelms my soul with anguish. This measure will likely be our only chance to take that step for some time. I ask for your aye vote.
Chairman Harshman, can you bring us home quickly?
Yeah, I'll bring us home. I think, just so you new folks, so how this is gonna work, we're gonna call, all in favor, aye, no, and then if somebody wants to call division, then we'll stand up. And if a bill fails a standing division, then we go to a roll call vote. And we haven't killed a bill on committee of the whole yet this year. And I'd hope one that's this important to our people is not the only bill that dies on committee of the whole this year. And I just think, I tell you what, I haven't seen the lobby like that. Maybe medical malpractice back in 2004. But I tell you, the tactics are the same. I mean, we went through the Tax 2000 study. We needed an income tax. What happened there? Well, a lot has changed, folks. We got this whole new sales tax set up. Got online sales tax. We got, in 2003, just after Tax 2000, we had 3% of our revenue from the per mill trust fund. Now it's up to 30%. And so here's what the deal is. It's all about delay. Study it. Study it. Study it. Well, we don't make laws in the interim. And here's the average. There'll be 20 new members here next year. Okay, so then the status quo wins, because you remember as new members, you come in, you're trying to find out where the bathroom's at, you're drinking from a fire hose, and it's a lot of work. And then it'll go into the 2/3 short session where you need a big vote to get something done. And then the lobby will fill up, and then they'll say, hey, study it. And then the 69th legislature, and then the 70th, and that's how this thing keeps going in the status quo, and then nothing ever happens. And in the meanwhile, property taxes continue to rise, because the little bills we just passed today, the ones for 3 years, then it's gone, if it makes it through the system. And then we've been told renters get harmed. And it's a concern, but I talked to a landlord in Casper. He says, well, the rent certainly won't go up. I'm raising rent now to cover property taxes. And again, nearly 3/4 of our families own their home. This is for folks who, and we want to get more people buying their own home. And then so delay this thing, cast some doubt on and then I think somehow kind of confuse the issue, Diapers was brought up. And I remember our 4 little babies when we had those discussions. I got to wait to buy a big box of diapers. But somehow we figured it out, and we made the important things important. And so I want to really focus on the big stuff. Tried to pass a 13th check for our retirees. Well, this bill is the 13th check. And they're not going to write the big check right around Christmas time to the county treasurer. This is a big 13th check, way bigger than what was proposed. It's a huge win for the men and women, the working men and women raising families and kids in this state, putting another $300 or $400 a month in their pocket. And then the young adults who are renting, who can now get into a home cheaper. So imagine living in a state that has no income tax and virtually no property tax. It's without a doubt the strongest statement, our statement on property rights in anybody's memory. And it'll provide the largest tax cut in our state's history. And so I sent you an email yesterday responding to some of the lobbyists talking. And I appreciate lobbyists. I've known them for years.
Chairman Harshman, let's keep it on the bill if we can, and avoid talking
Thank
about
you.
the folks out in the good lobby.
I appreciate you. Thank you, Chairman. And some of you giggle at my email. And because I mentioned, President's Day, and we're celebrating General George Washington, and he didn't stick his toe in the water on the Delaware and say it's too cold. I want to study it. Let me study it. And you think about Wyoming, you think about the guys who actually set the state up, the men and women, in 1869, because there wasn't a Wyoming territory. Hell, all our neighboring states wanted to swallow us up. We weren't even going to be a state. Our founders had leadership and fought it out, and we got this big square out in the middle. And then you think about 1890 in this building right down the hall. The U.S. Congress denies our active admission. And they say you can't do women's suffrage.
Point of order.
Representative, what's your point?
Mr. Chairman, we're debating a bill not receiving a history lesson on the state capitol.
If you don't
It's the
mind,
old
Chairman
history.
Harshman, keep it on the bill.
Thank you. It's old history, teacher, but I would say that general file rules are much more broader because it does apply to this. And in 1890, when our governor said, we're coming with our women or we're not coming at all.
Chairman Harshman, keep it on the bill. Let's wrap this up.
Okay.
I think we all know how
Yeah,
we're all
and
going
it
to
took
vote.
some leadership is what I'm saying, Mr. Chairman. I appreciate that, and I will. And then let's talk about taxes. Governor Hathaway, after he flew 50 missions over Europe.
Avoid proper names, Mr. Chairman.
He opposed. Okay, I got you. But I just want you to imagine the leadership. And Mr. Chairman, respectfully, it is our time. So I'd ask that you don't kill this thing today, because I think the people of Wyoming deserve more. And if we want to vote it down on Monday, let's vote it down. Thank you, all of you, for your patience and your good work.
All right. Anybody else want to give a history lesson? All right. Question being called. All those in favor of Vice Chairman Oakley's motion that when the Committee of the Whole rises to report it, do so with the recommendation that House Bill 203 do pass, please say aye. Aye. All those opposed, no. The chair is in doubt. All those in favor, please stand. All opposed? The vote count is 29 to 29. Having failed the standing division vote, a roll call vote is required. The chief clerk will please call the roll.
Alamand? Allred? Andrew? Angelos? Banks? Bear? Berger? Brown? Burkhart? Byron? Chadwick? Chestick? Clouston? Conrad? Crago? Davis? Eklund? Haroldson? Harshman? Heiner? Henderson? Hornock? Jennings? Knapp? Larson Lloyd? Larson JT? Lawley? Locke? Nyman? Newsom? Nicholas? Nemec? Northrop? Oakley? Obermuller? O'Hearn? Olson? Ottman? Pendergraft? Penn? Provenza? Rodriguez-Williams? Sherwood? Singh? Slagle? Smith? Stith? Storer? Strock? Stivar? Tarver? Tarver? Trujillo? Walters? Ward? Washut? Western? Winter? Wiley? Yin? Zwanitzer Dan? Zwanitzer Dave? Speaker Summers? Are there any changes? Brown? No. To aye. Larson JT? No. To aye. Further changes? Further changes. Closing vote. Vote closed. 31 aye, 29 no.
House Bill 203 has passed the Committee of the Whole. The next bill for our consideration is House Bill 36. The reading clerk will read the bill.
House Bill 36, sponsored by Select Federal Natural Resource Management. Natural Resource Protection Act, an act relating to protection of constitutional rights. Mr. Speaker, your Committee Number 1 Judiciary, to whom is referred House Bill 36, Natural Resource Protection Act, respectfully report same back to the House with the recommendation that do pass with the following amendments. Ayes, Representatives Craigo, Haroldson, Jennings, Nemec, Oakley, Rodriguez-Williams, Washut. Noes, Representatives Chestick, Provenza. Representative Washut, Chairman. This bill was re-referred to Committee Number 2 Appropriations. Mr. Speaker, your Committee Number 2 Appropriations, to whom is referred House Bill 36, Natural Resource Protection Act, respectfully report same back to the House with the recommendation that it do pass. Ayes, Representatives Henderson, Sherwood, Stith, Zwanitzer. Noes, Representatives Larson, Nicholas, Walters. Representative Nicholas, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Washut?
Thank you, Mr. Chairman. I move that when Committee of the Whole rises to report, to do so with a recommendation that House Bill 36 do pass, and I turn over explanation of the bill to the good representative from House District 28.
Chairman Washut, could you also move the standing committee amendment?
And I do move the Committee of the Whole amendment, or Standing Committee amendment as well. And the good representative will explain both.
Representative Winter.
Yes, thank you, Mr. Chairman. I bring to you House Bill 36, or the Natural Resource Protection Act. As a little background, this bill was brought forth to try to counter the goings-on over in the southwest part of Wyoming, where the Bureau of Land Management they're trying to do things over there with their resource management plan that makes no sense. And it's going to affect the whole state of Wyoming very soon if it ever gets passed. The amendment number, or the B amendment that they've are proposing is very restrictive to the mining and oil and gas industries, as well as the recreation and access situation over there. The state of Wyoming has, or this legislature has decided that the federal government shall comply with federal law when administering federal lands. The federal government arbitrarily restricting significant amounts of federal lands from public use is contrary to managing federal land under principles of multiple use and sustained yield. And I'll talk about the standing committee amendment right now. On page 3, line 5, we're talking about the, it was changed here to prohibiting the use of state resources for enforcement of federal regulation regarding federal land management, and then taking the penalty out. So when the governor determines that an executive order, a final rule, or regulation of the federal government does not comply with federal laws regarding federal land management, and upon providing notice, this state and all political subdivisions of this state shall not use any personnel, funds appropriated by the legislature or any other source of funds that originate within the state of Wyoming to enforce or administer that federal executive order, final rule, or regulation. Thank you.
Is there any discussion on the standing committee amendment? Any discussion on the standing committee amendment? Seeing none, all those in favor of the amendment, please say aye. Opposed, no. Standing committee amendment has been adopted. We are back on the bill. Speaker Summers.
So, Mr. Chairman, thank you. And I just have a question. You know, I'll end up voting for this, but I do have some questions. So I think about the endangered species in my county that eats my cows, and the fact that the state of Wyoming, through their good graces, reimburses my cows. And so I'm just thinking, if there was another species that did something like that to a landowner where the state had to, state felt responsible to do reimbursement, maybe that's the only thing keeping those guys going. So if we have a governor that doesn't recognize that and isn't willing to follow the law, he doesn't follow the state law. I said a governor. I didn't say the governor. I said if you get a governor, and a governor is in this, so I think I'm all right. No. This is a governor down the road. I just worry, anytime I see a bill like this, I worry once again, about the unintended consequences of what can happen. Now, we assume we'll always have a governor that will do the right thing at the right time, but that's not always the case. And I worry about us not being able to take care of our people because of a regulation we created, a law we created. And once again, I'll vote for this, but I'm not sure the committee fully thought about the unintended consequences of this bill.
Any other discussion on the bill? Any other discussion? Seeing none, and question being called, all those in favor of Chairman Washet's motion, then when the committee of the whole rises to report, it do so with the recommendation that House Bill 36 do pass, please say aye. All opposed, no. House Bill 36 has passed the committee of the whole. The next bill for our consideration is House Bill 60. The reading clerk will read the bill.
House Bill 60, sponsored by Agriculture, Excess Wildlife Population Damage Amendments, an act relating to game and fish. Mr. Speaker, your committee number 5, Agriculture, State and Public Lands and Water Resources, to whom is referred House Bill 60, Excess Wildlife Population Damage Amendments, respectfully report, same back to the House with the recommendation that do pass with the following amendments. Ayes, Representatives Alleman, Allred, Banks, Conrad, Crago, Davis, Eklund, Slagle, Winter. Representative Eklund, Chairman. This bill was re-referred to Committee Number 2, Appropriations. Mr. Speaker, your Committee Number 2, Appropriations, to whom is referred House Bill 60, Excess Wildlife Population Damage Amendments, respectfully report, same back to the House with the recommendation that it do pass. Ayes, Representatives Henderson, Larson, Nicholas, Stith. Noes, Representatives Sherwood, Walters, Zwanitzer. Representative Nicholas, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Eklund?
Mr. Chairman, I move that when the committee of the whole rises to report, it do so with the recommendation that House Bill 60 do pass. There's a standing committee amendment. I would also move standing committee amendment number 1 to House Bill 60. And this is another one you probably got some emails on, and I hope we'll be able to explain why it's before you to your satisfaction. I'm going to turn the floor management over to my colleague on the Ag Committee from the Great Plains in the northeast corner.
Representative Slagle.
Thank you, Mr. Chair. And House Bill 60 is a bill dealing with excess wildlife damage amendments. And basically what this is with the overpopulation of elk in our state. As you go through there, the main changes to our statutes right now are on page, they start on page 2 of the bill. The important parts that I want to point out are on line 7, we see added in there, and until July 1st of 2030. This program has a sunset date, that it's not going to last forever. And basically what this is you move on down on page 2, starting in lines 12 through 14. It's basically to compensate any landowner, lessee of state or private land, or agent for extraordinary damage to rangeland. Then as we turn on over to page 3, the important parts there are, we get down to 19, we see that talks about forage exceeding 15%. It won't be considered extraordinary damage unless there's over 15% gone, because we figured that 15% is what wildlife would probably normally use. Then goes on down and talks about it's only can be claimed if the population of wildlife exceeds the established numbers by the commission for 2 consecutive years. Then as we go on down on page 4, line 8 talks about a multiplier of not less than 150%. And that it's paid on 150% of the AUM rate established by the USDA for private land. And so basically, some questions have been brought up. How does it apply to state lands? Well, on state lands, you can only get back the portion you have paid for lease. No more, you can't make any more than you've paid on lease. And then probably the one thing that I would also go on to say is we had a constituent call in and talk to us about this 150% damage part, and he thought that was probably sufficient. An example he gave was if he had 100 head of elk on his place and the Game and Fish confirmed that that was the case, and he got reimbursed, it'd be about $28,500. But then he looked around at it and he said, okay, so if I had 100 head of elk, that would mean I wouldn't be able to run 50 head of cows. And this past year, if he hadn't had 50 head of cows on his place, the income they would have brought in was $75,000, meaning the amount of loss that he would have had from the elk grazing his place would have been $46,500. So it's a significant amount, even though the 150% of the AUM's compensation looks like a lot of money. It really isn't a lot of money when you lose the opportunity of what you could actually raise if you're running your own cattle. So with that, I will go ahead and move to the committee amendment that the good chairman moved. And basically what the amendment it does, on page 3 of line 14, it deletes the word consumption and inserts loss. On page 3, line 15, it deletes consumption by and inserts lost to. And on line 3, or excuse me, page 3, line 18, it deletes consumption and inserts loss. And the reason for this was a lot of the times when you have elk on your place, not only do they consume your forage, but they trample it and knock a lot of it down. That's why that was changed in committee.
Is there any other discussion on Standing Committee Amendment number 1? Seeing none, question being called, all in favor of Standing Committee Amendment number 1, please say aye. Those opposed, no. Standing Committee Amendment number 1 has been adopted. We now have some Committee of the Whole amendments. Representative Walters.
Thank you, Mr. Chairman. I would move Committee of the Whole Amendment number 1 to House Bill 60 and ask for your favorable consideration. And what this does, members, is this simply says that you have to allow unrestricted hunting on your property for the species in which you're claiming damages. And why do I think this is appropriate? It already says in the law you have to allow hunting, but that means you could allow one person to come hunt and you've met the maybe not the intent of the law, but you've certainly met the plain language of the law. So that's allowed hunting. But one person hunting is not going to move those animals off your property. It takes significant pressure to move them around. And if you don't want the damages, you need the pressure to move them around. And that's why, and if you want to be paid by the state for these damages, you need to allow
I'm sorry, point of order. I just, where's the
What's your
amendment?
point, Representative?
Where's the amendment? It's not online.
It's online.
I'll try again. Thank you.
Please continue, Representative Walters.
I just think it's appropriate. The wildlife of the state is the property of the state of Wyoming, not the property of the individual. And so if the individual landowner is getting compensated for the damages from that wildlife, then the citizenry of Wyoming needs the opportunity to go out and to pursue this game. So that's all this says. It says if you want to claim that, be paid and claim for the damages, great. You just need to allow folks to try and have the opportunity to pursue these animals. I think it's very prudent, very fair, both for the landowner and as well as appropriate for the sportsman in the state of Wyoming. So I'd ask for your favorable consideration and look forward to the discussion.
Chairman Eklund.
So if you'll look at the bill, in existing statute, that's already provided somewhat for that. It would be on page 220 through 22. No award shall be allowed to the landowner who has not permitted hunting on his property during the authorized hunting seasons. And the reason it's probably worded this way, if you had unrestricted hunting on your property, it would limit your rights as a property owner. That we would kind of know. They could camp, they could do whatever they want. That's unrestricted. You don't want them hunting on the property during the calving season. One of the things we're looking for to fix this problem is the harvest of cows. That just wouldn't be a good way to get rid of them. So you want the Fish and Game and those people involved in it. And that's part of why this amendment won't work out, and it's already in existing statute.
Representative Banks.
Mr. Chairman, thank you. I'll be quick. Urge you to resist this amendment. We worked on this in the interim. We had stakeholders at the table. The department that handles game and fish had their input. Landowners had their input. This is what we came together. The bill is good moving forward how it is. It meets the expectations of both of these groups, so please vote no on the amendment.
Representative Alaman.
Thank you. I urge a no vote on this amendment. This bill was drafted from what they call Area 7. Elk area hunting 7 is where one of the main problems is. The elk were put on there in the 70s by the Game and Fish. Today, and they had 300 head was their optimum number of elk. then it went to 500, and then it went to 800. And today, it's 1,800, and there's up to 7,000 elk. If you allow unrestricted hunting, it's gonna be a very big safety issue. And every time you shoot into a herd of these elk, they may take out several fences before they're done running. And I urge a no vote. Thank you.
Any additional discussion on Committee of the Whole Amendment number 1? Representative Walters.
Thank you, Mr. Chairman. To answer some of the questions, there was a comment made that if we allow unrestricted access, then people will be camping and other things like that. That's not the case. We said hunting. We didn't say camping. We didn't say we're taking away your entire private property rights. What this amendment does, it takes a landowner who potentially wants to have lots of elk on their property and lets them have lots of elk on their property and get paid for it. Because now they can claim damages. The state will come in and give them money to have a unrestricted, uncontrolled growth of the elk herd on their property. And then they can outfit it and bring in 1 or 2 clients and get paid even more money to use all of the state's wildlife for their profit. Because now we're paying them potentially twice that they would get paid, because they get paid by a hunter coming in, and the state will compensate them for the damages they can claim, because the damages are going to happen whether you're pro-hunting or not. And so this, by the way this is drafted currently, someone can, what I would say, double dip. They can take advantage on both sides of the coin. They can run fewer head of livestock because that's their choice with their private property, and get paid for that because they can claim the damages and limit the access. The point about it says already in statute that you have to allow hunting. Yes, it does. You have to allow hunting. 1 hunter is allowed hunting. It doesn't mean you have to allow 20 hunters. Under this current statute, it just means you have to allow it. It doesn't say how much you have to allow, and that's the whole concern with this bill. People will be allowed to claim damages and get paid for the wildlife that are causing the damage, that they're fine with having the wildlife there. So allowing the unrestricted portion that's in this amendment is really the goal. We want to have the people of Wyoming the opportunity to pursue the wildlife resource that is the people of Wyoming, if the individual wants to be paid by the state of Wyoming for the damages created. And we think of this in terms of big, large landowners. A person with 300 acres could claim these damages. 200 head of elk coming through in the evening would take all of the resource off that land overnight. So right there, and then they can get paid for it. Are they going to let their brother-in-law come hunt? They've allowed hunting. They've met the plain language, maybe not the intent, but the plain language of the existing law by letting 1 hunter in. And they got paid on a piece of property that today they're just happy to have it as a cabin and a family place for a retreat. Now they're making more money. The grazing of damages from their livestock are none, because they'd never had livestock in the first place. So now we're paying people that were not worried about livestock in the first place to have wildlife on their property while limiting access to everyone else. This says if you want the payment, you're going to let unrestricted access to the hunting privileges, just for that species. So again, on and for the amendment, enjoying the debate.
Chairman Zwanitzer.
Thanks. Just a question. So when we say unrestricted hunting, if this were to pass, the Game and Fish would assumedly up the number of licenses. It's still restricted or contained by the amount of, let's say it's elk, licenses given for that hunt area, correct? So there is still a proportional response if, instead of paying out grass damages. I guess my point is, we could pay damages, or we could sell more hunting licenses, landowner coupons. I mean, it just seems like in one way we're making money for our Game and Fish, and the other way we're just paying it out. Was that correct? Are there still those limitations with this amendment put on?
Representative Slagle.
Thank you, Mr. Chair. I would urge a no vote on this amendment. The department that regulates our game assured us that they would not issue damages to landowners that did not allow enough hunting to actually reduce the number by what the damage is equivalent to.
Chairman Washit.
Thank you. I'll support the amendment. I think this is the mechanism by which we allow Wyoming sportsmen who aren't going to be able to pay big outfitter fees to get access to all this land, an opportunity to fill the freezer, and at the same time diminish the number of these cow elk out there that are causing so much damage. On or for.
Chairman Eklund.
So, like I said, it's already an existing statute, the limitations on not allowing hunting. If you continue on through this, says any person failing to comply with the provisions of this section is barred from making any claim against the department for the damages. So the department will make the determination, and I think the bringer of the amendment more than likely has some hunting ranches near his where the elk are able to take refuge. The same thing has happened in this area of concern that was brought to us. It's not just one area, but it's a whole bunch of them. The main area has those preserves as well, but it'll be the determination of the department to see whether or not they've allowed access to allow harvest to get the quota numbers down. And that's what we're trying to do, is get the quota down. And there are a lot of ways of doing it. I'm not sure unrestricted access is the best idea in the whole thing. I'd leave some of the decision on this up to the department.
Representative Allemand.
Thank you. Area 7 has right at 5,000 too many elk. It's a safety problem if you turn 5,000 hunters to go out there and shoot each other. Big, huge safety problem, folks.
Representative Winter.
Yes, thank you, Mr. Chairman. Folks, this amendment is really complicating things for this whole bill. I would recommend we vote against it. These ranchers over there that are having the problem just want to run cows. They're not trying to, they're allowing hunting for the most part. And the ones that don't allow hunting, they won't get paid. So I think we just need to not, or at least vote against this amendment. Thank you.
Representative Walters, you want to bring us home?
Thank you, Mr. Chairman. I'll try and bring us home. Yes, to the question about, and I see we have some other speakers. This is going to be lively. To the question about license count, the license count isn't affected within this bill at all. And so the landowner can still offer unrestricted hunting based on the number of licenses that are out there. If no one shows up on their property to hunt, that's fine. The opportunity is what this is creating with this amendment. It's the opportunity to hunt on these properties. We have to be careful when we say the department will decide who's going to get paid and who's not going to get paid, because then all of a sudden the department can put themselves at risk of being sued for discriminatory practices. Because if I'm a landowner and I file for damages and they decide that they don't want to pay me just because arbitrarily they've decided they're only going to pay large landowners and not small landowners or something like that, that sets them up. This bill, the way it's crafted, says all landowners, whether they're large or small, will get compensated if the damages are met as set forth within this bill. And so the comment was made, ranchers just want to run cows. I agree, ranchers just want to run cows, but this bill sets it up for all landowners again, not just ranchers, landowners. That's who we're talking about here, to be compensated for damages. I gave you the example a moment ago where a landowner, 300 acres, can have a herd of elk come in overnight and graze everything off and be compensated based on this bill, because that's what the plain language of the bill says. You will be compensated if you apply and it meets the thresholds as set out in this bill. You never ran cows before on that property, so your livestock change and what your grazing ability is zero, but it's laid out here. This is what you can get paid, and so now you have the opportunity to get paid for something you never were in the past. To the point about 5,000 people out shooting at 5,000 elk because there's 5,000 elk in the area, I don't think that really is well-founded. The license count will still be the same based on what the department puts forward. so that there will only be a certain amount of licenses. Again, we're talking, provide the opportunity to pursue the state's resource here. That's all you have to do. And if you provide the opportunity, you are now eligible for the compensation. That's all this amendment does. On and for the amendment.
Mr. Speaker.
On and against the amendment, the current law allows opportunity, and it's a good opportunity and well-regulated opportunity. On and against the amendment.
Any further discussion on the amendment? Seeing none, all in favor of Standing Committee Amendment Number 1, please, Committee of the Whole Amendment Number 1, please say aye. All opposed, no? No. The chair is in doubt. All in favor, please stand. Committee of the Whole Amendment Number 1 has failed by a vote of 26 to 30. Representative Oakley, I believe you have a Committee of the Whole Amendment Number 2.
Thank you, Mr. Chairman. I would move Committee of the Whole Amendment Number 2 and ask for your favorable consideration. Members, pretty easy little amendment here. On page 4, line 9, we heard this discussion about the reason that it was not less than 150% of the private land lease rate, and the explanation was just because it's really not that much money. When I look at it, that doesn't seem fair. I think that the compensation that would make sense would be 100% of the private land lease rate. It is a compromise. We've heard, as we have heard some pushback from this bill. These are coming from Game and Fish dollars, and I don't think we need to go over 100% of the private land lease rate. So I'd ask for your favorable consideration.
Chairman Eklund.
And that was a point of contention during the subcommittee's work on the bill, because there was a committee within the Ag Committee that worked on it, department that Game and Fish were there, as well as ag groups, and I think it's fair enough. I think that I want to see this bill pass through 100%. Sounds fair enough. We didn't discuss it enough in committee as to why it went to 150, but it was contentious. I'd rather that we pass the bill and leave it at 100% instead of trying to get 150.
Representative Alaman.
Thank you. 100%, if a man has to move 400 head of cattle 200 miles to grass that he's renting, the 100% takes care of the grass that he's rented. But he's got to gather them, he's got to truck them, and the trucking will probably be considerably more than the 150%. So, you know, he's got to gather them, to truck them, the 100% would pay for the grass. He's got so many more expenses moving these cattle to where there's no elk and there is grass. Thank you.
Representative Slagle.
Thank you, Mr. Chair. This was come up to, but because of what we talked about, the example I gave earlier, the opportunity cost lost by not being able to graze your own cattle. The other thing that I would like to remind the body, private landowners have been running Wyoming's game for years for no cost. I think Wyoming private landowners need to be reimbursed for running the state's game. And so I think 150% on this example where there is proven damage is only reasonable. Please vote no on this amendment.
Speaker Summers.
Mr. Chairman, thank you. You know, I think I'm going to be in support of this. And the reason I'm going to support this is I think we start slow. We currently have a statute in place for extraordinary damage to grass that does not work. So we're reforming the system, I think, in a positive way. But I think it's more important to start slow, get the bill passed, and frankly, the opportunity cost, let's work on that over time if there's an opportunity cost that needs to be done. But I think the 100% is where we should be now, work on this a little more, take in more information, see how it all fits together. And because we're taking a step here that, and in an area that really needs it. First of all, I want to support those people. These are people that allow hunting. They got more elk than they know what to do with. Nobody can control them. They're having to bring in game and fish hunters to hunt them in the off season. You know, they butcher them and they take the meat, but it's out of control and it's ruined their livelihood. But we start slow, see if we can get this done. I support this amendment.
Representative Western.
Thank you, Mr. Chairman. I'm on for this amendment. Right now, I believe that the department in question is paying around 1.4-ish million a year in claims currently. All of a sudden, you offer an opportunity to landowners to say, hey, you have an opportunity to make 50% more in your claims than last year. I'm really worried about the financial impact this could have on the department in particular. That department is funded by sportsman dollars. So I think we really got to be conscientious about this impact. The fiscal note says it'll cost about another 1.8 million, but I think it'll be quite a bit more actually. Because when you increase the payout rate, that makes an incentive for more people to start taking advantage of this program. How much more? It's hard to say. But even if it's just 10, 15% more, that could have a serious financial impact on the department alone. I will certainly be bringing another amendment for the one we just voted down, but it's a different story. So that's why I ask you to vote no. Thank you.
Any additional discussion on Committee of the Whole Amendment number 2? Representative Winter?
Thank you, Mr. Chairman. We should realize that there was public participation in this effort to determine the value of what's being considered here. So as it was indicated before, there's a lot more expenses to doing what these ranchers have to do in order to get the value out of what they're trying to do. So we need to support or not vote for this amendment.
Any further discussion on the amendment? Representative Oakley.
Thank you, Mr. Chairman. I think we just heard agreement, at least from both sides of the aisle, a good old-fashioned compromise. So vote aye.
Question being called. All those in favor of Committee of the Whole Amendment number 2, please say aye. Aye. All opposed, no. No. Committee of the Whole Amendment number 2 has been adopted. We are back on the bill. Chairman Eklund.
So I would have brought some of this to your attention during the first amendment, but it would have got us off the amendment. This whole thing is an amendment. We're just, the damages to other crops, to property, this is in statute, and we're simply adding rangeland. And the reason that we're doing this was there are several herds of elk that have expanded to the point they've raised quotas until they finally stop, and then they're 2.5, 3 times over what the quota is. I guess I'd like to thank the Game and Fish for what they've started doing. And they're at the table. They want to resolve this as well. And I think the bill will incentivize them to do it. And that's what we're trying to do. The Ag Committee has it because we're seeing ranches that are 100 years old struggling during a drought year to keep a herd up. If anybody's tried to figure out how you feed several hundred cows without grass growing, it's no fun. But they've done it, and then they'd stockpile up pasture here and there for the winter, and the elk would consume it, and they can't seem to manage it. Game and Fish has some plans. They had one last winter that worked pretty well, and the game wardens are working on this now, especially in the cropland, but rangeland is another crop, and that's all we're doing is trying to add that to existing statute.
Any further discussion on the bill? Seeing none, question being called. All those in favor of Chairman Eklund's motion that when the committee of the whole it rises to report it, do so with the recommendation that House Bill 60 do pass. All, please say aye. Aye. All opposed, no. House Bill 60 has passed the committee of the whole. The next bill for our consideration is House Bill 75. The reading clerk will please read the bill.
House Bill 75, sponsored by Appropriations, Public Property Amendments, an act relating to public property and buildings. Mr. Speaker, your Committee Number 2 Appropriations, to whom is referred House Bill 75, Public Property Amendments, respectfully report same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Larson, Nicholas, Sherwood, Stith, Walters, Swanitzer. Excused, Representative Henderson. Representative Nicholas, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Nicholas?
Thank you, Mr. Chairman. I move when the committee whole rise and report. It does so with the recommendation that I make it to bed by 9 o'clock. No, I mean, that we pass House Bill 75 and ask for your favorable consideration.
And would you please move the standing committee, standing committee amendment?
And I move the standing amendment 101.
Representative Larson.
Thank you, Mr. Chairman. With your permission, I'll go through this 44-page bill and then do the standing committee amendment. And I hope that you will have, I hope you'll have patience with me. What this bill does is goes into all of the sections that deal with the physical assets that the state owns. So the SBC, A&I that have this building, office buildings around the state, the University of Wyoming, our K-12 statutes, and our community colleges. And the reason this came up is because this committee is often dealing, each year we deal with capital construction costs and major maintenance dollars, which you are still recall are substantial in amounts. And the question that we ask is how do we ensure that we're maintaining our physical assets for their full design life or longer? So I'm going to explain to you what this bill does in what I hope is short order. First, we go into the sections of the statute and conform all their definitions. For example, on page 6, we put the definition for capital construction into the state construction department statutes. And we did that by taking all the various definitions that are in all of those different sections and made one. And then we had to go, and that's why this bill's so long, because then you had to go into section 21, 15, 18, and 21, where the University of Wyoming is, and make those conform to refer back to that. That's why we have 44 pages. But the importance of this conformity was to keep consistency so that when contractors, architects, engineers, and agencies are bidding on a project or referring to a project, that the definition would be the same. For example, capital renewal would be the same for school buildings as it is for community colleges or a state building. The second thing we do is we focus on identifying what major maintenance is. And that definition is to repair, replace of complete major portions of the property system at an irregular interval which is required to continue the use of the property at its designed capacity for its designed intent. And the rationale is that all components have a life cycle and that we should anticipate the need to replace these systems as they reach end of life. If we replace these systems at the appropriate time, we maintain or extend the life cycle of the property as a whole. Put in other words, we're trying to preserve the asset for the full design life. For each of these systems, as you might understand, or components, to reach their full life cycle full life cycle before we use major maintenance dollars to replace them, routine maintenance is critical. If you don't change the oil, your engine doesn't last as long. If you don't rotate your tires, you replace them sooner. So we're wanting to make sure that we're doing routine maintenance before we expend major maintenance dollars. And then the third thing we do is require the state properties, university, community colleges, and school districts to develop and maintain a major maintenance plan, require them to submit their major maintenance expenditures and commitments to the State Construction Department for review at the end of the year. If in the review process, if in the review process the department identifies a major maintenance expenditure that was earlier than anticipated or before the end of the life expectancy of that component, equipment, or system, they are to determine if the premature failure was due in whole or in part because of neglected routine maintenance. The entity would then be responsible to cover proportional costs attributed to the neglected routine maintenance from their own budget, not from major maintenance dollars. And fourth, and so what we've done there is we're kind of putting some accountability in that you got to do routine maintenance to make sure that these things reach their end of life cycle. And the fourth thing we do is provide avenues for the agency to dispute a claim of negligence, and we provide an avenue for an agency or an entity to request additional funding to cover major maintenance projects if their major maintenance reserves are insufficient. So, Mr. Chairman, with that, I would move the Standing Committee Amendment number 1. I think we moved it already, didn't we?
You did.
And what this amendment does is in the first draft of the bill, we had the reporting before from their major maintenance. They developed a plan and submitted it for review before they'd done the major maintenance. What we found is we visited with the university and the community colleges is it made more sense in current practice is to review them after they've completed them. And they develop the priorities, they complete them in case there's a switch. So this 3 or 4 page amendment was correcting all of that language to change it from before to after. And Mr. Chairman, I'd be happy to answer any questions.
Any questions or discussion regarding Standing Committee Amendment number 1? Seeing none. Question being called. All those in favor of Standing Committee Amendment number 1, please say aye. Opposed, no. That amendment has been adopted. Back on the bill. Any discussion on the bill? Seeing none, question being called. All those in favor of Chairman Nicholas's motion that when the Committee of the Whole rises to report, it do so with the recommendation that House Bill 75 do pass, please say aye. Those opposed, no. House Bill 75 has passed the Committee of the Whole. The next bill for our consideration is House Bill 43. The reading clerk will read the bill.
House Bill 43, sponsored by Select Federal Natural Resource Management. For state forestry, good neighbor positions, and act relating to state lands. Mr. Speaker, your committee number 5, Agriculture, State and Public Lands and Water Resources, to whom is referred House Bill 43, state forestry, good neighbor positions. Respectfully report, same back to the House with the recommendation that it do pass. Ayes, Representatives Alleman, Allred, Banks, Conrad, Crago, Davis, Eklund, Slagle, Winter. Representative Eklund, Chairman. This bill was re-referred to Committee number 2, Appropriations. Mr. Speaker, your Committee number 2, Appropriations, to whom is referred House Bill 43, State Forestry, Good Neighbor Positions. Respectfully report, same back to the House with the recommendation that it do pass. Ayes, Representatives Henderson, Larson, Nicholas, Sherwood, Stith, Walters, Zwanitzer. Representative Nicholas, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Eklund?
Mr. Chairman, I move that when the committee of the whole rises to report, it do so with recommendation that House Bill 43 do pass, and I'll turn, this is a committee bill by the Federal Natural Resources Committee, and I'll turn it over to one of the members for floor management.
Representative Heiner.
Thank you, Mr. Chairman. I'll cut to the chase on this. When the Forest Service, the federal government, was in front of our committee, they talked about all the things they're trying to do, they're not able to accomplish, why it was taking so long. We asked them, what can we do to help? And they said, give us some more Good Neighbor employees. The Good Neighbor program is where they pay for some employees within our state forestry. They pay for them, and then when they need something done, the Forest Service, it goes through our contracting department rather than the federal government. It says it cuts their time in half if they have to rebuild a trail, to sell timber, or to build fences. So this moves our allowed number of FTEs from 1 to 4, all paid by the federal government, and contract employees, which they use during the summertime, from 4 up to 6. And I stand for any questions.
If there's no questions, the question being called, all those in favor of, House Bill 43, say aye. All those opposed say no. House Bill 43 has passed committee of the whole. The next bill for consideration is House Bill 86. The reading clerk will read the bill.
House Bill 86, sponsored by Representative Brown. Vehicle lien amendments, an act relating to personal property liens. Mr. Speaker, your committee number 8, Transportation, Highways, and Military Affairs, to whom's referred House Bill 86, vehicle lien amendments, respectfully report, same back to the House with the recommendation that it do pass. Ayes, Representatives Berger, Brown, Nemec, Obermueller, O'Hearn, Pendergraph, Smith, Stivar, Wiley. Representative Brown, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Brown?
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report, it do so with the recommendation that House Bill 86 do pass. And I will make a very quick and down and dirty explanation of the bill. Ladies and gentlemen, I'm sure you have been contacted by the lenders in your neck of the woods that are interested in this bill. And what it basically does is we have a law in Title 31 right now for abandoned vehicles that says if you abandon your vehicle and it sits on a tow lot for more than 5 days, the tow lot has to do a lien search. We don't have that same language basically for towed vehicles. So if somebody has a vehicle towed from the scene of an accident, they don't care about it or something along those lines, those vehicles are sitting on these tow lots and accruing fees at $20+ a day. And in some cases are accruing so many fees that they're worth more than the value of the vehicle. All we're trying to do at this point is make sure that the lien holders, if they have a vehicle that gets put on a tow lot, they are notified by the tow company after 5 days of that vehicle sitting on their lot. This allows the insurance adjusters to come out there, allows everybody to come take a look at the vehicle that they need to, and then immediately just has a lien search be done with the Wyoming Department that handles our transportation, and then the lien holder of the vehicle is notified and they can go get the vehicle. And that's all this bill does, Mr. Chairman. I'll stand for any questions.
Any questions? Hearing none, the question being called. All those in favor of House Bill 86, please say aye. All those opposed say no. House Bill 86 has passed the committee of the whole. The next bill for our consideration is House Bill 125. The reading clerk will read the bill.
House Bill 125, sponsored by Representative Haroldson. Repeal gun-free zones and preemption amendments, an act relating to concealed weapons. Mr. Speaker, your committee number 1, Judiciary, to whom is referred House Bill 125, repeal gun-free zones and preemption amendments, respectfully report, same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Crago, Haroldson, Jennings, Nemec, Oakley, Rodriguez-Williams, Washit. Noes, Representatives Chestick, Provenza. Representative Washit, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Washit?
Thank you, Mr. Chairman. I move that when the Committee of the Whole rises to report, to do so with the recommendation House Bill 125 do pass. And I further move the adoption of the Standing Committee amendments. Turn over the explanation of both to the good representative to my right.
Representative Haroldson.
Thank you, Mr. Chairman. So today we're looking at House Bill 125, the elimination of gun-free zones. Obviously, we had this conversation in our introduction. I'm going to jump right into kind of what we saw as we went into committee and kind of the testimony so we can dispense with the committee of the whole, or sorry, the standing committee amendment. As we were looking at it, there were some concerns that came forward. The first concern was what happens when you get a lot of alcohol at a sports stadium over the mountain and the potential for a firearm. And we said, yeah, that probably wouldn't mix too well. So on page 2, line 21, we struck out of there the or professional for the sports section of it, and it reads, any public school, public college, or university, and then it says athletic event that does not sell alcoholic beverages is placed in there. So we got that alcoholic beverage concept in there. So anywhere that sells an alcoholic beverage would be out, just like it is in the rest of our statutes with bars. And then we also went in there and added on page 3, allowing the carrying of a concealed weapon into facilities where otherwise prohibited by law. That would be illegal, and that would be to take care of our federal statutes. We don't want that to be getting in the way, and obviously we have no jurisdiction in federal buildings. And then also after that, we had a conversation with law enforcement. They said, you know, we don't want it to be a situation where someone gets unruly and someone tries to say, hey, you know what, came to the kids' basketball game, got unruly, and we said, hey, we got to escort you out. And they say, well, I've got my concealed carry permit, you can't escort me out. So that on page 3, line 14, it says, after person who, insert knowingly, and after another person, insert for, so it would read, any person who knowingly prohibits entry to another person for lawfully carrying a concealed weapon into a place authorized pursuant to the subsection. So it just gives that law enforcement that opportunity to not get themselves into a pickle. So that's the committee amendment, and would ask for any questions on it.
Any discussion on standing committee amendment
Question.
number 1? Seeing none, question being called. All in favor, please say aye. Aye. Opposed, no? No. Standing committee amendment has been adopted.
With that,
Representative
Mr.
Haroldson, do you want to address your committee of the whole amendments, or you want to
I'll move on to my committee of the whole amendment, sir.
Please
Mr.
proceed.
Chairman. So I move committee of the whole amendment number 1 to House Bill 125 and ask for your favorable consideration. We did have testimony from the department that cares about if you're healthy and the department that cares for our families. And they had some concerns about what this would do for our mental health facility, for our boys and girls homes that we have in the state, as well as the situation where a family may be in a separated state and there's visitation, and they just didn't want it to be a situation we placed firearms into those situations, which we fully agree. So in this, it would go back and it goes into page 1, line 6, it says, it places an N, and then line 7, exception, and inserts exceptions. And so it goes on to page 3, which is kind of the meat of that conversation. And what it does on page 3, it says, it inserts 2 more sections. One would be allowing the carrying of a concealed weapon within state agency operated health and human service settings or health and human service facilities that are licensed by the Department of Family Services. So that'll cover the boys and girls homes, that'll cover our facility over on the other side of the state, that would cover all of our, I guess it's in here, so the Department of Family Service locations. I have cleared this with both of those departments, and they are very much for it. The other thing we actually had a conversation with from our community colleges is they said some of the laboratories might have explosive gases or explosive powders like laboratories, and they said, can you put something in there? So we put 5, which is the V, which allows the carrying, so this would not be allowed, the carrying of a concealed weapon with any facility where explosive or volatile materials are present. So these are just cleanups to help these different agencies and their concerns, and the different schools and their concerns. So with that, I would ask for your favorable consideration.
Representative Yin.
Thank you, Mr. Chairman. So I guess the only question I have, I do appreciate the amendment. Does this cover public county hospitals or only hospitals run by the state?
Representative Haroldson.
Thank you, Mr. Chairman. So this would be anything that would be covered under so I got to back up. We had licensed in here as an option, and we had regulated. We had a couple different words in here. They said if it was regulated, every single like chiropractor officer, I mean, because everything's regulated by the state. And then they also talked about the concept of licensed. Well, everywhere also has licensing. So they actually, the department that worries about our health stated that they didn't want that in there because they felt that that would create problems. So on a county ran, if it's truly county ran and does not have a provider in there, it would not cover them, no.
Any other discussion on Committee of the Whole Amendment number 1? Seeing none, question being called. All those in favor, please say aye. Aye. Opposed, no. Committee of the Whole Amendment number 1 has been adopted. Chairman Newsom.
Thank you, Mr. Chairman. I move Committee of the Whole Amendment number 2 to House Bill number 25. And so in 2017, we passed a bill that would allow for armed staff in schools. Several of our districts have adopted that. One of that is my home district in Park County 6. So my concern is we have a trained staff, armed trained staff, and now we're going to allow citizens off the street to come into our schools concealed carry. My fear is that one of our teachers will shoot a citizen who comes into our school legally. That's a concern of mine. And I've gotten several emails that said, you're just fearful. I am. But my bigger fear is that if this bill passes and any citizen is allowed to come into our school when we have trained staff, that we will no longer have trained staff, that we will lose that group of people that has volunteered to be trained staff because they will no longer have that certainty that anybody that comes into our school that's not one of them is a bad guy. So my fear is that we will lose the people that are protecting our school children every day because they don't want that uncertainty. So when I saw this bill, I thought, this is an easy fix. We can just say, if you have trained staff that are outlined in 21.3.132, then the school district can have the opportunity to have a permit system for people that might want to come into the school carrying, which would be fine. Then as I went over to our good friends at LSO and said, I want to do this, I want to say, if you have enacted 21.3.132, then you're in a special class because you have this trained staff. And they said, no, you can't do that because this bill repeals 21.3.132. So on repealing 21.3.132, we no longer have consistency or training requirements or anything for staff in school that are carrying weapons. So the amendment you see before you is not perfect. It's not what I wanted, but it's the only way I see to protect the armed staff in my school. So I would stand for any questions.
Representative Singh.
Thank you, Mr. Chairman. Question to the bringer of the amendment. Aren't visitors to schools required to have a very clear badge or name tag that indicates that they are in fact a visitor?
I know when
Chairman Newsom.
I'm sorry.
Chairman Newsom.
Thank you, Mr. Chairman. I know when I go into our school to meet with youth groups or whatever, that I have to do that. And that what I think, but I'm not concealed carrying. So I don't know how we would have a badge on someone that would say they're concealed carrying. I'd be open to that as a way to let people know that there is someone armed in their school. I just worry that we'll lose our armed staff.
Representative Haroldson.
Thank you, Mr. Chairman. So first of all, I want to just say I definitely appreciate your concern. I definitely see your concern. Upon talking about the repeal, so as we drafted this, they said if we don't repeal this, there would only be three schools in the state that the staff could legally carry, and they would be exempt. The staff couldn't legally carry because they would be held under a different statute than the citizen coming in with a concealed carry permit. And so that's why that repeal had to go in. They said if not, it would be a carve out of people who couldn't have that privilege of having the Second Amendment right to bear arms in that position. So that's where that came in. That had to be lifted to make that reality. There's a number of states that have done this, but Utah is the state that I want to talk about. In 1994, they did what we're talking about doing today. And since 1994, it hasn't proved to be a problem. In fact, quite the opposite. Utah has not had a school shooting since 1990, early 90s. And so it's definitely a conversation that needs to be had. I hear the concern. I definitely honor that concern. I don't want to trample on anyone's concerns in this, but at the same time, not allowing, I mean, if this amendment were to pass, there are schools that very seriously could be unarmed again. And that's a conversation we have to have. I mean, we're gonna have schools that are not gonna have people in them that could defend our children. So if this passes, I don't believe the nature of the bill has definitely changed exponentially.
Representative Banks.
Mr. Chairman, thank you. I think something that's been overlooked in this amendment is the training that is required to go into both me as a concealed carry permit holder, as well as the staff inside the school. I don't believe that we're going to have concealed carry permit holders walking around brandishing their weapons up and down the hallways in the school that would inspire the staff to and then pull their weapons. The realities of that and the training involved to be able to carry, both as staff in a school as well as me as a responsible gun owner citizen, is something that has to be overlooked. It is something that has to be looked into and thought about. And there's a reason that they are concealed carry permits. And the training that's required for all responsible gun owners to be able to do this, and the training that this bill says we have to have in order to do this is in the bill. So I don't think this amendment is necessary and urge your vote no. Thank you.
Representative Larson.
Thank you, Mr. Chairman. I appreciate the amendment, and I think it's worthy of consideration. I remember in my first session here when we went through the training before this Capitol was all done, the security here in the Capitol come in and talk to us, and they says, all right, we know that probably 90% of you have a firearm in your vehicle. We got that. It's okay. We understand that probably right now there's probably at least half of you carrying. And they were right in here. And of you that are carrying, most of you have had your concealed weapon training. You understand, you've been raised with firearms your whole life. Here's why we ask you not to do that in the Capitol, is because in the event that there was a shooter here, we have all of this security here, similar to what the good representative school district has and my school district has. And if there is an unauthorized shooter come into play, you're going to pull your firearm, and we're going to pull our firearms, and we're going to, and the security guys are going to know who the security guys are, but they're not going to know who you are. And so you may be trained and you may not, but the security people don't know who you are, and they just try to avoid that. And so I think that we have to be careful, and I think that this amendment is a thoughtful way to address the concern that kind of comes into play there.
Representative Pendergraft.
Thank you, Mr. Chairman. If you look at crime statistics, as I have done several times over the last several years, you will find that consistently one of the lowest groups of people involved in gun crimes is concealed carry owners. Lower percentage even than police officers. This reflects on the attitude of the people who go to the trouble to get this permit and the training that it takes to be there and the discipline that we employ. It just, I'll leave it at that. Thank you.
Representative Klauston.
Thank you, Chairman. When I was a school board trustee, this is one of the things that we handled. Our duly elected board voted, after several meetings with our communities, that we would train and arm some of our educators. We worked with the Sheriff's Department, Police Department to put resource officers in our bigger schools. I also firmly believe that each community and each school district should make their own policy. I'm a local control believer. What one school district in one part of the state may want is not what another district may want. Our university has its own board of trustees. I think they can pick for themselves. You know, I worry about our university has lots of Wyoming people that they know how to handle a gun. They know it's safe to have a gun. But we also have lots of foreign students and students from other states that really have no gun experience. I really firmly believe that we need to let each school district and institution set their own policy. So I'm in favor of this amendment.
Representative Smith.
Thank you, Mr. Chairman. I just want to express I speak against this amendment because I do believe when we rely on other security forces, there is a false sense of security. I was in this chambers last year after hours, and there was at least a half dozen of us, and there was somebody who made their way up near the speaker's desk that was either under the influence or mental illness or something, and our wonderful Sergeant of Arms went and confronted the individual to get them off the floor, and the response time was 20 minutes after hitting the panic button. So I think talking about the security, nothing happened, nothing came of it, which we were all fortunate, but I think by not being able to protect yourself, it's a false sense of security. And the benefit is this is concealed. So if no one knows another person has a firearm, there's really no threat. And then also, I believe people are great at discerning where a real threat is. We typically have that little check in our gut of, hey, this is a good situation or a bad situation, and we can perceive if somebody is a true threat or not. And we make those split seconds really, really rapidly. So on and against this amendment.
Representative Yin.
Mr. Chairman, thank you. Just to comment on the training portion, I hold a concealed carry permit. I don't have it on me. It's in my desk at home. I did not bring it because I'm not concealing carry here. because, well, frankly, it's not allowed currently. But to grant some clarity on the training, just in case any member doesn't have a concealed carry permit, it's a one-day training. You learn about gun safety. You don't learn about how to act in a shooter situation. So there's no shooter training. It's really just how do you handle the gun. Then you get your fingerprints taken by the sheriff's office, and they grant you a permit after a background check. So as far as, if you want to consider that training, sure, but it isn't how to respond in a shooter situation. Thank you, Mr. Chairman.
Chairman Newsom?
Thank you, Mr. Chairman. So, you know, I've been accused of wanting to gut this bill. I don't. A couple of years ago, I was a co-sponsor on a repeal gun-free zones bill. That's not my goal. My goal is to protect the people that are in my schools, protecting our kids.
Representative Haroldson?
Thank you, Mr. Chairman. And you guys, friendly fire is always a real thing. Law enforcement trains on it extensively. That is something that you always have to be concerned about. But one of the things we have to understand, talking to the concept of local control on this, the state of Wyoming needs to make a decision if we believe that gun-free zones are constitutional or not, if they're right or not. That's really what this comes down to. We see statistics time and time and time again that when a school has a sign that says there may be armed people in the school, that type of a sign, people who would have nefarious intent drive on. They do. These mass shooters, in their diaries, in their conversations, they drive past hard targets to find soft targets. That's just the way they work. So I think an unintended consequence of this would be the opportunity that we continue to have soft targets in our state. So I definitely ask that we do say no to this and move on with the bill as it stands.
Representative Rodriguez Williams?
Thank you, Mr. Chairman. On and against the amendment, the reality is that lethal threats need to be terminated using lethal force, and time is of the essence. The other reality is that Board of Trustees need to really start encouraging staff to train, to participate in the previous law that we've already passed. This amendment destroys preemption and it allows local control. And like the previous speaker just said, we need to make a decision on and against.
Chairman Washut?
Thank you, Mr. Chairman. So the tightrope we have to walk here is Article 1, Section 24 of the Wyoming State Constitution that says the right of citizens to bear arms in defense of themselves or the state shall not be denied, period. That's all it says. And so when we're talking about local control, that's great until local control says we're going to deny this constitutional right. And then that's what brings us to the point that we're at. But it does seem that this bill has elements that kind of work against these few districts in Wyoming that did step up to the plate, train their personnel, and address that safety concern several years ago. And now we're putting them in a very awkward position. So I don't have an answer, but I do want to just remind everybody about that constitutional tightrope that we have to attend to.
Chairman Newsom?
Thank you, Mr. Chairman. This is not perfect. This amendment was crafted because the other 21.3.132 was repealed. If we put 21.3.132 back, then I believe, and I will certainly get with the sponsor of the bill, but then I believe we can say if somebody has enacted 21.3.132, that they can then have maybe a different standard. So, you know, I don't know if I were in my school district as an armed staff member and I was then told that anyone can walk in off the street carrying, and the whole thing about concealed carry, these people are trained to recognize concealed carry. Because not every shooter's going to walk in, not every bad guy shooter's going to walk in brandishing a weapon. They are probably going to conceal that weapon until a time when they decide it's right to start firing. So, and our staff is trained to recognize when somebody's concealed carrying. That's part of their training. So I know this is not perfect. I'm not trying to gut the bill. I'm just trying to protect my people.
Any further discussion on Committee of the Whole Amendment number 2? Seeing none, question being called. All those in favor, please say aye. Opposed, no? No. That amendment has not been adopted. We are now on Committee of the Whole Amendment number 3, and I am looking for the sponsor of that amendment, which is Chairman Northrup. All right, we will withdraw that. Chairman Zwanitzer.
Sorry, Mr. Chairman. Chairman Northrup did ask me to withdraw that motion on his behalf.
Thank you. It's considered withdrawn. We're back on the bill. Any more discussion on the bill? Seeing none, question being called. All those in favor of Chairman Washett's motion that when the Committee of the Whole rises to report, it do so with the recommendation that House Bill 125 do pass, please say aye. Aye. Those opposed, no. House Bill 125 has passed the Committee of the Whole. The next bill for our consideration is House Bill 93. The reading clerk will read the bill.
House Bill 93, sponsored by Representative Heiner. Animal Reimbursement Program Account Amendments 2, an act relating to agriculture. Mr. Speaker, your committee number 2, appropriations, to whom is referred House, maybe back up. Mr. Speaker, your committee number 5, agriculture, state and public lands and water resources, to whom is referred House Bill 93, Animal Reimbursement Program Account Amendments 2. Respectfully report, same back to the House with the recommendation that it do pass. Ayes. Representatives Alleman, Allred, Banks, Conrad, Crago, Davis, Eklund, Slagle, Winter. Representative Eklund, Chairman. This bill was re-referred to Committee Number 2, Appropriations. Mr. Speaker, your Committee Number 2, Appropriations, to whom was referred House Bill 93, Animal Reimbursement Program Account Amendments 2. Respectfully report, same back to the House with the recommendation that it do pass. Ayes. Representatives Henderson, Larson, Nicholas, Sherwood, Stith, Walters, Swanitzer. Representative Nicholas, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Eklund?
Mr. Chairman, I move that when the Committee of the Whole rises to report, it do so with the recommendation that House Bill 93 do pass, and I turn over the explanation of the bill to the bill sponsor from the banks of the river that runs green.
Representative Heiner.
Thank you, Mr. Chairman. It's getting late. We're all ready to go home. But simply what this bill does, there's a ceiling on the amount that they can reimburse ranchers for quarantine animals. Right now, that ceiling is $25,000. This bill will raise it up to $50,000. There's an account of money that's set aside for this in our livestock board. It's got $540,000 in it. Typically, they have 2 or 3 incidences or events of quarantine, and they usually spend around $50,000 a year to help those ranchers out. Now, this year, we have 2 ranchers that are in the middle of this, and they are already exceeded $75,000 each in verifiable impact for quarantine. It's kind of risen up a lot this year. We know our wildlife have brucellosis. It's getting into our herds. And back in 2004, we spent millions of dollars because we lost our brucellosis-free status. So, Mr. Chairman, there is an amendment. I move amendment number 1 to Committee of the Whole Amendment number 1 to House Bill 93 and ask for your favorable consideration. Simply, this amendment makes the enacting immediate as soon as the bill can be, the necessary steps taken. And I ask for favorable vote for that.
Is there any discussion on the amendment? Seeing none, question being called. All those in favor of Committee of the Whole Amendment number 1 to House Bill 93, please say aye. Aye. Opposed, no. That amendment has been adopted. We are back on the bill.
Just ask
Representative
for,
Oakley, do you have something?
Yes.
Please proceed.
Thank you, Mr. Chairman. Very briefly, I just in support of this and appreciate your consideration. Some of these people are going through truly difficult and cumbersome times, and it is a governmental restriction that we want people to abide by, and they are, for the health and of our herds and not spreading disease. Again, and the reality is, as we heard, the costs will exceed this greatly, but it's a little bit of help that we can do. So I'd appreciate your consideration. Please vote aye.
Speaker Summers.
My apologies, Mr. Chairman, but I am going to speak on this. I'm on in support of this bill. I had a bad test one year and it didn't turn out to be anything, but it took them forever to figure that out. The amount of expenses that were incurred just to figure out that test was tens of thousands of dollars. I had to pay for trucks that got hauled back, to haul cows back. It was a mess. These people need it. It's the real deal. If you're caught in one of these governmental traps, you might say.
Anything else on the bill? Seeing none, question being called. All those in favor of Chairman Eklund's motion that when the Committee of the Whole rises to report, it do so with the recommendation that House Bill 93 do pass, please say aye. All those opposed, no. House Bill 93 has passed the Committee of the Whole. Mr. Majority Floor Leader.
Thank you, Mr. Chairman. I move the Committee of the Whole rise and report.
You've heard the motion. All those in favor, please say aye. Opposed, no. The motion carries.
Chief Clerk will read the Committee of the Whole report. The reader will read the Committee of the Whole, not the Chief Clerk. Though maybe she should. Do you want to read it?
Mr. Speaker, your Committee of the Whole, having had under consideration bills on general file, begs leave to report as follows. House Bill 134, do pass amended. House Bill 52, do pass amended. House Bill 103, do pass amended. House Bill 203, do pass amended. House Bill 36, do pass amended. House Bill 60, do pass amended. House Bill 75, do pass amended. House Bill 43, do pass. House Bill 86, do pass. House Bill 125, do pass amended. House Bill 93, do pass amended. Representative Crago, Chairman.
Chairman Crago.
Mr. Speaker, I move the adoption of the Committee of the Whole report.
You have heard the motion. All those in favor say aye. All those opposed? Motion carries. Congratulations, Chairman Crago. All right. Thank you. Representative Trujillo, do you have a privilege?
Privilege of the floor, Mr. Speaker. Thank you.
Please.
Just a quick note for anybody that is staying in Cheyenne over the weekend, our local Knights of Columbus needs your help in raising money to fix their kitchen. They're having a dinner from 4 o'clock tomorrow and an auction at 6 p.m. It's being hosted and emceed by our local ALF, who does our nonprofit fundraisings called Thankful Thursday. A quick tidbit on that. Thankful Thursday started in 2010, and since then we've had 322 Thankful Thursdays, raising $3,216,000 for all our local charities here in Laramie County. I'd appreciate your support for Knights of Columbus tomorrow at 4 o'clock. Thank you.
Awesome. Thank you for that. Messages from the Senate.
Message 147. Mr. Speaker, the bill listed below passed the Senate on third reading in an amended form by the vote indicated. Senate File 22, Public Service Commission Electricity Reliability, ayes 31. Message 148, Mr. Speaker, the bill listed below passed the Senate on third reading by the vote indicated. Senate File 26, Special District Vacancies, ayes 31. Message 149, Mr. Speaker, the bill listed below passed the Senate on third reading by the vote indicated. Senate File 27, Special Districts Bond Elections Exception, ayes 31. Message 150, Mr. Speaker, the bill listed below passed the Senate on third reading by the vote indicated. Senate File 79, Malt Beverages Franchise Agreements, ayes 31. Message 151, Mr. Speaker, the bill listed below passed the Senate on third reading in an amended form by the vote indicated. Senate File 100, Prompt Payment of Insurance Claims, ayes 31. Message 152, Mr. Speaker, the bill listed below passed the Senate on third reading in an amended form by the vote indicated. Senate File 113, Light and High-Profile Vehicle Closures, 2, ayes 19, noes 12. Message 153, Mr. Speaker, upon reconsideration, the bill listed below passed the Senate on third reading by the vote indicated. Senate Joint Resolution Number 2, Foreign Adversaries Prohibited Property Ownership, ayes 24, noes 7. Sincerely, Ellen Thompson, Senate Chief Clerk.
Yeah, privilege of the floor, Representative Singh.
Thank you, Mr. Speaker. Privilege of the floor.
Please.
Thank you, everyone. If you have not made plans for your Saturday evening this weekend, I'd like to invite you to the Lincoln Theater for Songs of the Silver Screen, being performed by the Cheyenne Chamber Singers. I'll be one of the friendly faces in the performance, so I'd like to see you there.
Awesome, that's great. So we got to have 32 people. You guys can draw straws, but we're going to go through standing committee report just so we have enough bills to work on. Reports from standing committees.
Senate File 2, sponsored by Management Council. Legislative Budget, an act relating to appropriations for the legislature. Mr. Speaker, your Committee Number 2 Appropriations, to whom is referred Senate File 2 engrossed, Legislative Budget, respectfully report, same back to the House with a recommendation that do pass with the following amendments. Ayes, Representatives Henderson, Larson, Nicholas, Sherwood, Stith, Walters, Zwanitzer. Representative Nicholas, Chairman. Senate File 3, sponsored by Labor, State Employee Leave for Volunteer Fire or Volunteer EMS, an act relating to administration of government. Mr. Speaker, your Committee Number 10, Labor, Health, and Social Services, to whom was referred Senate File 3 engrossed, State Employee Leave for Volunteer Fire or Volunteer EMS. Respectfully report, same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Chadwick, Clouston, O'Hearn, Penn, Trujillo, Ward, Yin, Zwanitzer. Noes, Representative Hornock. Representative Zwanitzer, Chairman. Senate File 4, sponsored by Labor, rehiring retired firefighters, continued retirement benefits, an act relating to firemen pensions. Mr. Speaker, your Committee Number 10, Labor, Health, and Social Services, to whom is referred Senate File 4, rehiring retired firefighters, continued retirement benefits. Respectfully report, same back to the House with the recommendation that it do pass. Ayes, Representatives Chadwick, Clouston, O'Hearn, Penn, Trujillo, Ward, Yin, Zwanitzer, Noes, Representative Hornock. Representative Zwanitzer, Chairman. Senate File 20, sponsored by Corporations, electricity rates for costs that do not benefit Wyoming, an act relating to public utilities. Mr. Speaker, your Committee Number 7, Corporations, Elections, and Political Subdivisions, to whom is referred Senate File 20, electricity rates for costs that do not benefit Wyoming. Respectfully report, same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Chadwick, Harrelson, Knapp, Newsom, Olson, Ottman, Wiley, Yin. Excused, Representative Harshman. Representative Olson, Chairman. Senate File 30, sponsored by Judiciary, influencing jurors and witnesses, judges amendment, an act relating to crimes and offenses. Mr. Speaker, your Committee Number 1 Judiciary, to whom is referred Senate File 30 engrossed, influencing jurors and witnesses, judges amendments, respectfully report, same back to the House with the recommendation that do pass with the following amendments. Ayes, Representatives Chestick, Crago, Harrelson, Jennings, Nemec, Oakley, Rodriguez-Williams, Washit. Noes, Representative Provenza. Representative Washit, Chairman. Senate File 60, sponsored by Select Federal Natural Resource Management. 2024 Large Project Funding, an act related to the Wyoming Wildlife and Natural Resource Funding Act. Mr. Speaker, your committee number 2 appropriations, to whom was referred Senate File 60, 2024 Large Project Funding, respectfully report same back to the House with the recommendation that it do pass. Ayes, Representatives Henderson, Larson, Nicholas, Sherwood, Stith, Walters, Zwanitzer. Representative Nicholas, Chairman. Senate File 47, sponsored by Appropriations, Law Enforcement Retirement Contributions, an act relating to compensation and benefits. Mr. Speaker, your committee number 2 appropriations, to whom was referred Senate File 47, Law Enforcement Retirement Contributions. Respectfully report same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Henderson, Larson, Nicholas, Sherwood, Stith, Walters, Zwanitzer. Representative Nicholas, Chairman.
No way. All right, Mr. Majority Floor Leader, that clears the deck.
Mr. Speaker, I move that the House stand adjourned until 10 a.m. Monday, the 26th day of February 2024.
You have heard the motion. Do we have any committee announcements? Chairman Nicholas.
Thank you, Mr. Speaker. Your House Appropriations will meet at 8 o'clock to have the presentation of the Senate File 1 at 8 o'clock on Monday.
Chairman Olson.
Thank you, Mr. Speaker. Your House Corporations, Elections, and Political Subdivisions Committee will meet on Monday upon noon recess in E005 to consider one Senate File 21, Public Utilities Net Power Cost Sharing Ratio.
Chairman Washit.
Thank you, Mr. Speaker. Just a reminder, your committee number 1 will meet on Monday morning at 8 o'clock. Here, Senate File 45 and Senate File 35.
Chairman Zwanitzer.
Thank you, Mr. Speaker. Your committee number 10, Labor, Health, Social Services, is going to meet at 8:30 on Monday. Again, 8:30. Enjoy that 30 minutes to hear Senate File 5, organ transplant recipients, and Senate File 18, hospital district created entities.
Chairman Nicholas, for
I
your
knew I had
second
another
bite.
list. At noon on Monday, we will do Senate File 38 in gross, Senate File 48, and Senate File 49, and any referrals that we have.
All those in favor of the Majority Floor Leader's motion say aye. All those opposed, no. We stand in recess until Monday, 10 a.m., February 26, 2024. And I have somebody's phone up here. Is that Representative Craigos? Whose phone?